Good morning, everyone. I'm going to wait a few more moments as we all join on audio and, if appropriate, video, and then we'll get started in about a minute. All right, I'll go ahead and get started with introductions. It looks like everyone is out of the waiting room, at least for now. Good morning. It's a beautiful day and we're all in front of our computers. It's June 17th, 2024. I'm Nicole Kinsey, the presiding hearing officer for the Administrative Hearings Office of the State Water Resources Control Board. This is the second pre-hearing conference on the pending petition for assignment of state filed application 25517 and accompanying water right application 25517X01, and the pending request for release from priority of state filed applications 25513, 25514, 25517, the unassigned portion, 22235, 23780, and 23781 in favor of water right application 25517X01 of Sites Project Authority. This pre-hearing conference is being conducted by Zoom web conference and also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of the recording along with the Zoom generated transcript to the administrative record that is available on the board's FTP site. We also have a court reporter with us today. That's Ms. Nelson. And we will be posting, once we receive that transcript, we will also be posting that transcript to the board's FTP site, excuse me, for this proceeding. The YouTube recording is also available on the AHO YouTube webpage. If at any time this morning you're experiencing technical difficulties trying to communicate with us by Zoom, please send an email to the AHO at adminhrgoffice@waterboards.ca.gov, or you can send one to the site's email address also. AHO staff will be monitoring that email inbox and can let me know. Assisting me today are a number of staff from the Administrative Hearings Office and the Division of Water Rights who are here on the Zoom call. If at any time I experience technical difficulties this morning during this conference and I'm not able to rejoin the Zoom conference within a few minutes, one of the AHO staff will call a recess until I'm able to rejoin. I think, as I mentioned, we do have a court reporter with us today, Ms. Nelson, and you will have access to that transcript. And with that, I think we're ready to move to appearances. I will also, I think, it looks like everyone has their name updated in Zoom, and I appreciate that. That helps us with our record keeping here. But if at any time, I may go through, I think we had someone call in by phone number, and I may ask you to identify yourself, but I'll just march through the appearances and then at the end wrap up and see if there's anyone else on the call. For appearances, as we did before, I'll identify each of the persons and entities who filed NOIs. And if you're representing that party or yourself, please unmute your microphone and state your name. I'm generally going to try to proceed in the order of what we have proposed as the order of proceeding. So it'll be a different order than last time. It's not quite so alphabetical. And we'll see if we can move through this pretty quickly. So I'll start with Sites Project Authority.
Good morning, Aaron Ferguson for the Sites Project Authority.
Good morning. California Department of Water Resources.
Good morning, Eric Soderlin, appearing on behalf of the Department of Water Resources.
Thank you. United States Bureau of Reclamation.
Good morning, this is Amy Oftenberg for Reclamation.
Thank you, good morning. State Water Contractors.
Good morning, Jenna Mandel Rice on behalf of the State Water Contractors, and I'm joined today by Kira Johnson and Ethan Nocera. Kira will be taking over for me at about 10 a.m. As I mentioned, I have an unavoidable conflict starting about that time.
Great, thank you very much. Central Delta Water Agency et al., and that includes South Delta Water Agency, Zuckerman Mandeville Incorporated, Delta Farms Reclamation District number 2030, and Rudy Musi Investment LP.
Good morning, Dean Reese, for all those parties.
Good morning. Thank you. County of San Joaquin.
Hello, OSHA Missouri for County of San Joaquin, and I'll probably be mostly listening today. I'm feeling a little under the weather, so if I don't join more, I'll just defer to Mr. Ruiz to help me out today. Thanks.
Great. Thank you. And thank you for joining us. And I hope you feel better soon. The summer colds are the worst. T&M King Farms.
Good morning, Ben King for T&M King Farms.
Good morning. Clark Ornbaum.
Presiding Officer Kunze, Clark Ornbaum is having a problem getting the link. If somebody could actually email him the link, he'd appreciate that. He wasn't sure how the amended notice was, so he's trying to get on right now by phone.
Okay, thank you very much, Mr. King. And I will look to my team if we could email Mr. Ornbaum. And just if Mr. Ornbaum is listening, I don't know if he's able to listen on YouTube. That link, the Zoom link in the original notice and the amended notice should be the same, I believe. So I think either one should work.
I'm not sure. I just checked in with him a few minutes ago, and he did not have the link, and so I'm not sure what the facts are. But
Okay,
I just want
we'll try to get an email over to him with the
Thank
link
you.
as well. Thank you. Let's see. Would the Calusa Indian Community Council? Friends of the River.
Good morning, Don Mooney on behalf of Friends of the River. And I think also on here are Jan Dorman and Keiko Mertz.
Great, thank you. California Sport Fishing Protection Alliance.
Again, Don Mooney and also Chris Schutz is on with California Sport Fishing Alliance.
Thank you. And we'll keep going on this. Sierra Club.
Same here. And I don't know if there's a Sierra Club rep here. I was looking through to see, but Don Mooney on behalf of Sierra Club.
Great, thank you very much. And Aqua Alliance. California Water Impact Network.
Good morning. This is Adam Keats on behalf of California Water Impact Network.
Thank you. Good morning. Cal Wild. Fly Fishers of Davis. Northern California Council of Fly Fishers International. Oh, I just received a message that Mr. Ornbaum has joined the meeting. Mr. Ornbaum, if you're there and are able to introduce yourself, please. You may have to come off mute. Well, we'll try again. We can't hear you, Mr. Ornbaum, but we will check in again. I'll proceed through the rest of our appearances, and then I will check in with you again to see if we can work through technical difficulties. We do want to hear from you today. Restore the Delta. Save California Salmon.
Regina Chicazola with Save California Salmon, and I believe our attorney, Cecile Willie, is also in the room.
Thank you very much. And then the next I have as a group, so I'll call them as a group: San Francisco Baykeeper, the Bay Institute, Defenders of Wildlife, and Golden State Salmon Association.
Good morning, Eric Busher, San Francisco Baykeeper, and it looks like Ashley Overhouse is with us as well.
Thank you. And then I have another grouping here: Water Climate Trust, Waterkeeper Alliance, and International Rivers.
This is Conrad Fisher on behalf of that group.
Thank you. Good morning.
Good morning.
And I see also separately, I was going to call the Winnemem Wintu tribe. The-
morning. This is Clark
Yes,
Ornbaugh.
please. Mr. Ornbaum, we can hear you. Thank you. Thank you
Thank
for
you.
introducing yourself. I'm glad you could join us.
Thank you.
I have Pacific Coast Federation of Fishermen's Associations et al., which includes North Coast Rivers Alliance, Pacific Coast Federation of Fishermen's Association, San Francisco Crab Boat Owners Association, and Institute for Fisheries Resources.
Glenn Spain representing those organizations.
Thank you. Good morning. Center for Biological Diversity.
Good morning. This is John Bussey, and I see Francis Tenney is also on for Center for Biological Diversity. Thank you.
Thank you. Trout Unlimited. Richard Morat. And then finally, Patrick Porgans. All right, I've proceeded through the list of parties. My intent was not necessarily to go through the list of interested persons because I'm not sure how many will be on the call today. But I think the way to handle this is if there's anyone who has not had a chance to introduce themselves and would like to do so, if you would maybe raise your virtual hand, or if you can't find the virtual hand, you're welcome to speak up. And then I was going to, while you're thinking about that, let's see, it looks like we may have at least one unidentified iPhone. If you are on the call, and it may be that you can't tell because you're not on your computer, but can anyone attest to being the iPhone call-in?
Conrad Fisher is on an iPhone.
Oh, thank you. No, you're identified, Mr. Fisher. We have you.
Oh, okay. Okay.
I don't think that's you. I could be wrong.
Ms. Kenzie?
Yes.
I neglected to introduce Alicia Forsyth from the Sites Project Authority. She's on as well.
Oh, thank you. Thank you, Mr. Ferguson. Well, look to my team. If we continue to not have someone speak up and be attributed to the iPhone, let me know and we'll try to make sure we know everyone who's on the call. Is there anyone else who has not had a chance to introduce themselves and who plans to participate today?
Good morning, Ms. Quincy. This is Marley Nelson. I'm the court reporter. I'm actually
you're on the iPhone.
I'm on the
Thank
iPhone. Thank you.
Thank you. I appreciate it, Ms. Nelson. Now we know.
Thank you.
All right, so let me jump into the purpose of the status conference as I see it, and of course we can work through any issues that you're bringing to us here today. The AHO did issue an amended notice of hearing and pre-hearing conference and a procedural ruling letter on June 5th. That notice identified some issues for us to talk about today, and then I also received some pre-hearing conference statements, and I read all of those. Thank you very much for those. I received those from the authority, what I'll call the environmental groups collectively, and I appreciate that joint effort, Central Delta Water Agency et al., and Mr. King. I also received a letter about protest settlement terms from state water contractors. So state water contractors, DWR, and the authority, and I believe the date on that was about June 12th. Were there any other filings related to this conference that I missed? I just want to make sure. Sometimes we try to keep things in order, but all right, good. Thank you. I also wanted to acknowledge that we did receive witness lists on June 12th, and we had, I think, one or two come in on the 13th for technical challenges, and that's understood. But we have received those. Those are all available on the FTP site and should be available to you there. The one other small matter that I wanted to mention is that Mr. King did ask for a sample exhibit index, and we provided one to him, and I wanted to mention that to all of you that we have that sample exhibit index. You don't have to follow it exactly, whatever presentation you think works for you, but if you'd like a sample, there is one available in the correspondence folder on the FTP site, and that was an attachment to our email response to Mr. King. So that is there.
Thank you, Presiding Officer Kunze. Also, I mentioned on my witness list, Jeff Davids informed me that today, who was a witness I proposed, that he is already engaged with the Sites Authority and cannot serve in that capacity. So I'd like to bring up the issue about whether or not what we can ask the DWR, or perhaps expanding his time to talk about the sustainability issues for the Calusa Subbasin and the development of the Calusa groundwater sustainability plan for the Calusa Subbasin, since he is the chief consultant for it.
Thank you, Mr. King. That you are ahead of me, but not too far ahead of me. So let's talk about it. Let's go ahead and talk. Well, let me do this. I'm going to lay out what I see as the agenda so everyone can start thinking about it, and then we will address that issue first because that was on my list. So my outline for our agenda today is, first of all, what I called specific witness issues, this being one of them. I just had a few questions or maybe things we should think about with respect to the witness lists. Second, I'd like to talk about the schedule, the hearing schedule, and other deadlines associated with the hearing. I also have on here to talk about the site visit, both the date and the procedures, and discuss that. I think we should touch on next the order of proceeding when we get to the hearing. Number 6 I have here is discussing the court reporter issue, and then a few, I think, smaller issues. One related to the state water contractor's letter. We can get to that, but we can briefly maybe talk about that. There was a question also from the authority about water availability issues and the role of the division, and we can talk about that. And then I briefly wanted to touch on, I think there were some questions about the timing of an operations plan, and we can briefly touch on that issue as well. And then, of course, there may be other issues that any of you would like to raise, but I think I tried to go in somewhat order of the biggest issues first, with the exception of these kind of smaller witness issues. So with that, I think we'll turn first to Mr. King, that you brought up. Thank you. I have you first on my list anyway. We also noticed that Mr. Davids was listed as a witness for both. So I wanted to, what I think the way to handle this actually is witnesses that are called by another party. It gives you the opportunity to cross-examine that witness, and you can cross-examine that witness related to any matter that's relevant to the hearing issues. You're not limited to the scope of that witness's direct testimony. So you would have a chance to ask Mr. Davids questions outside of the scope of his direct testimony on cross-exam, and that's one way for us to do that, if that.
Great, thank you. So then the question would be is how much time would be allotted for him? Whether or not I wasn't clear about how much rebuttal time there would be, or discussions, because one thing that's foundational to this is under statutes for the application, I believe it's 1050, there has to be sufficient water for the application. And since the application has been filed by sites in 2022, the Department of Water Resources has deemed the groundwater sustainability plan for the Calusa Subbasin to be incomplete. Part of that is a cumulative groundwater deficit of several 100,000 feet. There are other issues, and so we're in a situation where we don't know how to reach. There's the proposed the comment period is also not even finalized for the groundwater sustainability plan. That ends in June 24th, and then we won't expect the DWR to make a determination probably until sometime late this year or next year. So it's foundational to your consideration, I believe, under statute, that there is sufficient water for that. And so it also relates to a lot of other issues of water quality, issues of groundwater dependent ecosystems, just environmental impacts, and just overall public trust issues. And so I don't know what the answer is, but it's this, we're talking about a greenfield project on the west side of Sacramento Valley, very important for the state, but also same time, there are a lot of issues regarding the sufficiency of water, both from your statute requirements of the 1050, but also the areas of origins statutes, and we have a groundwater sustainability plan that's incomplete, and that was determined subsequent to the application.
So I think I'm going to very briefly summarize, which is you have a lot of questions, it sounds like, for Mr. Davids, and you will on cross-exam. So, and I have not set time limits for cross-examination, and we'll get to that later in our discussion today, but I don't plan to do that now. I think it makes sense for us to see that everybody's testimony, and then we can talk about times for cross-examination. This is a little different because you already know that you may be, you may have questions outside of the scope of Mr. David's direct testimony. So what I'll take this conversation as is a request from you to have some leeway and the amount of time you would have to ask questions of Mr. Davids, and that I should take that into consideration when setting these cross-exam limits.
Correct, and I appreciate that, but also the other development is that DWR has decided not to actually present a case, and so I know they're going to be part of this proceedings, but there's nobody to actually, unless the DWR wants to come in and talk about that. The consultant for the Colusa Subbase for the Colusa Groundwater Authority is our best case. And then also there's just, it's a small county with a lot of conflicts. And so, Mr. Davids, I have perfect confidence in him being given an unbiased opinion, but he does have fiduciary duty to the Groundwater Authority, as does the Council for the Groundwater Authority, which is the same council the Sites Authority. So, there's multitudes, and then the consultants are the same in a lot of cases too, for projects, etc. But if the DWR wants to interject into it, it's great. But as I understand it, they're going to be selective in their engagement in this. But if we have enough time, I can both the issues, the foundational issues, 1050, but also the area ordinance issues, and then several other environmental issues, public trust that I need to foundational to my protest. Thank you.
Thank you,
Ms.
Mr.
Kinsey,
King.
can I comment?
Yes, Mr. Ferguson, go ahead.
A number of witnesses are clearly going to have complicated testimony. It's going to require some detailed and extensive cross-examination. My request would be that we establish a fixed time, which it sounds like you're inclined to do, for cross-examination, and then provide additional time on a showing of good cause. And not try to at this point kind of come up with a special circumstance for Mr. Davids.
That's fair. Thank you, Mr. Ferguson. I'm putting out there markers of what would may be relevant. I think we're going to get into this discussion. I noticed we have in the order of 90 witnesses identified, and we have about 90 hours of hearing time. So we're going to have to figure out how to streamline this process. So I'm mindful of that, and I am inclined to set fixed limits subject to flexibility if it's productive.
Thank you.
Productive line of questioning. Thank you. I did want to note, Mr. King, I think, particularly given that you are not an attorney, and this is, as I understand, your first AHO proceeding or State Water Board proceeding of this nature, if there are witnesses that you believe are essential to our understanding of the hearing issues, there is a subpoena process. I mean, there is a process for getting witnesses in front of us. We would need to work on that quickly because we've already now passed the deadline for identifying witnesses, but that is another avenue. There's a method for calling what we'd call an adverse witness, someone who has not necessarily been called by a party, but who you think that the water board should hear from on certain issues. So
it's fine. I actually I'm a graduate at UC Davis Law School, and I practice law in the state of New York. But I got out of my litigation rotation because I never wanted to be involved in litigation. But my purpose here is to represent my family's farming interests, but also represent what I believe is important for the legacy and the issues of the Colusa County specifically, and the Colusa Subbasin more generally.
Wonderful. Then, Mr. King, I will say there is an administrative subpoena process, and you can look into that. There should be some other information available on the board's hearings page, but we can, like I said, if that's an avenue that is going to happen, we need to move forward quickly because there would need to be the opportunity for those witnesses to object to the subpoena, and we'd have to do that motion.
Yeah, I have no intent. I believe that we have enough engagement that you'll have enough to make a decision, or whatever form of decision you might make. And so I don't intend to overly complicate it, nor do I have capacity to. since I'm just acting on my individual, I am the only person acting on one of my issues. Thank you.
Thank you, Mr. King. Is there anything else we should talk about, Mr. King, on with respect to your case in chief or any of your issues?
Yeah. So thank you for that. My case in chief is going to be focusing on inclusive subbasin issues primarily, and so it may be a little bit different some of the environmental parties in that I'm really focusing primarily, first of all, on the natural flows into the Colusa Trough, which are the Stone Corral and Funk Slough. And so one of the issues I want to bring up is I believe there are flows from natural flows into Funk's Reservoir that should be within the scope of the state's license, their APA rights under that, and I believe there should be at least some discussion about documentation of how much and what's happening to that. Those also may have water quality issues because they drain the area, which is the Old Salt Lake in the Funk's Reservoir and go into TC Canal right now. That's my understanding. So some clarification on that. The other issues that I wanted to just bring up is I looked at the witness list, and I understand the Colusa Indian community is not here and Kachadehe is not here, but I do think you have, my understanding is that you have the State Water Board has tribal issue responsibility in an executive order and tribal consultation. And looking at the witness list, I believe that this is actually a tribal consultation. Should be also considered a tribal consultation also. I believe your responsibility is really to meet the native, the Quetzaldehi and Quetzaldehi and the other tribal entities here where they are from capacity point of view. These issues are very difficult and complex, but I believe you're obligated to really have a hearing that's accessible to them and for they can actually be engaged with that. And so I would bring up the tribal consultation responsibilities of the State Water Resource Board in this proceedings. And also, part of my pre-hearing statement was really a point of historical equity. And I believe that this is a real issue of equity from a tribal consultation point of view, and that some of the participants in the site authorities are actually direct descendants of people who actually were part of removing the native peoples from the area of the site's reservoir. Colusa County in itself could be considered Indian country because I believe Quetzaldehi is probably the largest employer of people within Colusa County, and to the extent that water is exported out of the basin and impacts the ability of Colusa County to be a vibrant agricultural community, it's going to affect the long-term economic sustainability of Quetzaldehi in particular. So, I know there's a lot there, but I would actually urge you to look at your responsibilities on executive orders and the tribal consultation that you are required on your policy, I believe, in June of 2019.
Thank you, Mr. King. And I think that it actually segues well with my next issue that I had identified. But first, I do want to address this issue of consultation because this is one that I've been thinking about, and it's a little tricky. The problem here is that consultation, as I understand it, is a conversation that occurs with the chairman of our board, and that's a face-to-face sit down. The problem is that we're here under the laws applicable to this proceeding and under which I'm obligated to follow. We can't have those ex parte conversations. So we're in a situation where I am, and the board is certainly mindful of how do we run a hearing that is equitable and in which all have an opportunity to participate and present important information. But also I have to do it within the limits of our authority to act. So I don't think this is a situation where consultation is possible because of the ex parte rules. And that there may be a larger conversation about what, dealing with that issue, but in my position in this proceeding, I'm up against that challenge. That said, I do think it's quite important that the tribes have the opportunity to fully participate, and I want to make sure we are mindful of that. I did have identified, and this is not for you, Mr. King, necessarily because you're not representing the tribes, but I will say this in case.
In no way am I representing the tribes. So.
Right. But for those who are listening, it's just a thought. When I went over the witness list, I noticed that a number of tribal members are planning to testify, which is I think is a good thing, and I want to hear from you. I noticed that these witnesses are identified as experts, and that may be, I don't know what the content of the testimony would be. That might be right. But expert testimony is different from lay testimony in the sense that expert testimony is not based on the personal perceptions of the expert. And then also subjects that testimony to the evidentiary code 801 to 805. That's in our regulations. So I just wanted to put a mention out there whether and this may apply to others in the witness list about whether this is expert testimony or lay testimony, and the possibility that maybe it's being they're a combination thereof. It might be both.
Right.
Not at the same time, but I did want to raise the issue.
Thank you, and I of course I'm just raising these issues, and so because they are all related. The other last point is on the water availability analysis, I find it difficult to engage it because I'm really focusing primarily on the Stone Corral, Funk Slough, and whatever may be flowing into Funk's Reservoir. Is there a way that we could separate that out for everybody knows what we believe the water is available from the ephemeral creeks that feed into the Colusa Trough, and specifically the ones that are subject to the state's application?
So at this point, Mr. King, I'm not going to get into the substance, and I can't direct the authority how to put on their case, but this may be a conversation you can have with the authority separately, if they're willing to walk you through their water availability analyses. And then also it may be an issue appropriate for cross-examination of their witnesses as to how they conducted that analysis and whether the witnesses can give you more information about certain portions of that and break it out. I think this may be an issue we come back to. I mean, if I have more questions after we hear the testimony, that may be an issue that I want to follow up on. But at this point, we'll set it for when we get into the substance. I will turn first to Mr. Ferguson and then Save California Salmon.
Thank you, Ms. Kinsey. I want to return to your question, Mr. King, about his case in chief. Mr. King hasn't identified any witnesses other than Mr. Davids for his case in chief. So we would object to him putting on any case in chief testimony at this point, now that Mr. Davids is not going to be participating on his behalf. Secondly, the water availability analysis does contain a section on water availability related to Funk's Creek and Stone Corral Creek. So I would encourage Mr. King to review that and proceed with cross-examination as you suggest. We certainly will have witnesses, as you can see from our witness list, that will address that issue. So,
right. Thank you, Mr. Ferguson. And then I'll just follow up to say, because it's not necessarily Mr. King, you can submit exhibits. It's not necessarily the case in these proceedings that you need sponsoring testimony to support exhibits. So I just wanted to make that clarification for all. And then I'll turn to, I think it's Ms. Chicazola with Save California Salmon.
Hello, can you hear me?
Yes, I can. Please go ahead.
Sorry, I do not have my camera on. We're all very sick in my household. I cannot, of course, speak for the tribes, but several of the tribes that are going to be represented are on our board of directors, and one of the experts we did help retain. And they are speaking specifically to the issues of tribal beneficial uses, tribal water rights, and tribal cultural uses of the waterways and the lands within the project area. So I feel like, obviously there might be some discussion on whether or not people are considered experts or non-experts within their testimony, but I could not see who could be a better expert to things such as tribal beneficial uses and tribal cultural uses than the tribal practitioners themselves. And most of the tribal leaders that are actually on their councils that are testifying. So I'm not sure if you want to have a different discussion or if you're able to have a different discussion, but you also have issues of first in time, first in right water right holders within this. So anyway, I just wanted to say that I do think that Mr. King's point is well taken. I know that you have to deal with ex parte rules and consultation rules, and this becomes very complicated. But I did want to just speak to the fact that I think that most of the tribal witnesses that are listed are very much experts within their fields. And that's all I wanted to say. Thank you.
Thank you. I appreciate that. And I appreciate the opportunity to clarify my statements. It was not an implication that there isn't expert knowledge involved here. That is not certainly not what I intended. I just meant in the term of art as expert testimony is defined. It just let me back up. These administrative hearings, the normal rules of evidence, the rules of evidence that apply in court don't apply here. We have a lot more leeway to bring in evidence that's relevant and that's helpful, and that it's the type of evidence on which a reasonable person would rely in making a really significant decision. There are one or two limitations on that. There are a few limitations related to hearsay, although generally hearsay comes in. And then there are the expert testimony rules of evidence that do apply by the State Water Board's regulations. So I just wanted to point out that that area of expert testimony is one area where we do have some evidentiary code obligations. And I just wanted to raise that for everyone's consideration. It was not at all, you can certainly be an expert on a lot of topics and be offering lay testimony or be offering expert testimony as it may be. So thank you for that chance to clarify.
And I was not speaking to every person who's on the tribal expert witness list either. Just I wanted to say some of them I know are considered experts in their field. So
thank you. And yes, I completely appreciate that. And also I don't know the content of their testimony. None of us do so far. So that may be quite right to designate them as expert witnesses. Before we move away from that question, my next specific witness issue that I wanted to raise was a question for some of the NGOs about their non-expert witnesses. But before we move away, are there any other concerns about the witness lists, the designation of witnesses, specific issues that might be helpful to address at this point? All right, I'll turn, and I don't know which of you it's best to turn to first as a representative, so I may leave that up to you. But I had a question. I know there were a large number of witnesses, non-expert witnesses from each of the different entities, the NGO entities, who were designated to provide direct testimony about the interests of the particular organization. And I wanted to explore that a little bit because it would take a lot of time. And I'm wondering if that's an area where maybe summaries of direct testimony may not be particularly helpful. But I wasn't sure I know the designation was to testify as to the interests of the organization, but I wanted a little more clarity about how that relates to the hearing issues and material and disputed issues of fact. And if is there anyone who would volunteer to address that? I see, Mr. Boucher, you came off.
Yeah.
I'll pick on you. Thank you.
Yeah, Eric Busher and Don or John or others can add to this. Our expectation or our intent in including those witnesses was that there be an evidentiary record that, right, for Baykeeper, this project impacts our members and our mission. It's something that we've worked on and care about. We care about the outcome. I don't expect that to be a lengthy declaration. I would suspect there is no actual dispute with the sites folks about, right, those kinds of things, and would hope that we could skip the testimony related to that because they don't need to cross-examine, right, me or our executive director about what Baykeeper's mission is, I would imagine. So hopefully that would be very streamlined, but we want to make sure that there's an evidentiary basis for why we're here and why we're impacted for at least our group, and I think similar for the other NGOs.
Thank you. And I'll turn to others if they want to add, but I guessed that it might be a standing, to dot your I's and cross your T's with respect to standing, but I didn't want to assume. So Mr. Mooney, I see you're off mute. Would you like to chime in?
Yeah, I was just going to reiterate what Eric had said, is that yes, it's just more about standing and making sure we have a complete record in terms of the party's interests in the outcome of the hearing.
Thank you. So on that, and this is jumping a little bit to one of the next issues about schedule, but my inclination, and then also about time for direct summaries of direct testimony, my inclination is to not make a decision about time limits for summaries of direct testimony until I know who wants to cross-examine who, and I'm not going to be asking for a absolute commitment, but I do think I want to ask all of you, once you've had a chance to see the written testimony, to identify for me if there are parties who you do not intend to cross-examine. And this mostly, I'm going to recognize, is mostly a burden on the authority, because I have a feeling most of the authorities' witnesses will be cross-examined. So that is something we can talk about, I think, when we get to it on the list, but that's a little foreshadowing of where I think we may be able to add some efficiency to this process, because again, just to reiterate, that the testimony comes in writing. So the hearing process itself is really a chance to cross-examine, frankly. But sometimes with particularly complex testimony, it's helpful for me to hear a summary, to hear it again, frankly. I will have read all of the testimony before we get to the hearing and hear from those particular witnesses. But if it's particularly complex and technical testimony, it is helpful for me to hear another summary and have sometimes a PowerPoint presentation is quite helpful. And then if there's a witness who is going to be extensively cross-examined, it's sometimes helpful to have an immediate refresher in advance of us jumping into that cross-examination. But again, I just wanted to remind all of you that the hearing it really is about cross-examination, because that direct testimony comes in writing. I will read it. Other members of the advisory team will read it as well. And that all comes into our record. So if I think that's an area where we can get some efficiencies. Maybe, I mean, since I framed it up, let's go ahead and continue to talk about this issue. So the backing up a little, a general observation that I had, which is we have, I think when I looked at the witness lists, we had a request for something like, I think in the order of 25 or 26 hours of summaries of direct testimony. It sounds like we can get some efficiencies there. So we'll really need to think hard about how to do that. Another way, I think, as I mentioned, is that we have something like 90 witnesses identified. And I believe with 15 hearing days, roughly, and accounting for lunch breaks and other breaks, at most, we have about 90 hours of hearing time, I think. So we need to make this efficient, because there will be witnesses that will take more than an hour with presentation of a summary, if it's particularly technical, and cross-exam. So we need to find some ways to streamline this. I think I mentioned I'd like to set a deadline for you to tell me, and really I'm looking to you, Mr. Ferguson, because as I said, I think the burden is going to be more on the authority here, to tell me which other parties' witnesses you want to cross-examine. And again, it wouldn't be a binding commitment, but it's to help us run a more efficient hearing process. But I do want to make sure you would have time to look at the direct testimony and then make at least an initial assessment of who you do not want to cross-examine, because that would affect my decision about summaries of written testimony. So I'll look to you, Mr. Ferguson, and then I'll look to the room about any comments or concerns or other matters about how we can make this presentation of direct testimony more streamlined. And if there are any concerns about this identification of witnesses you'd like to cross-examine. And so with that, to you, Mr. Ferguson.
Well, the authority can certainly plan on reviewing the testimony and provide you with a sense of who it would like to cross-examine, and try to provide you a sense of who we don't think we need to cross-examine.
Right. Really, that's the bigger one.
Yeah, we're happy to do that. And I understand. So we'll be looking at it to see if, as Mr. Busher explained, it's really a summary of the organization's attributes or characteristics and or mission statements and stuff that, yeah, I would generally agree that the authority is unlikely to dispute those sorts of statements. So, but we certainly need to see the testimony first.
Right. And that is certainly understood. And let's get back to, we'll get back to that, talk about setting a date. Maybe once we get into some of these deadlines a little more.
Okay.
Thank
you. And then Mr. King, I see you came off mute. Go ahead.
So one of my questions, and like I said, I is of course through your procedure, but would it be possible to have opportunity to bring the sites authority, the applicant's witness list back out towards the end, if it's because it might be a way to actually expedite, because issues will come up, especially with the tribal entities speaking, raising issues, and that will perhaps maybe be respective of the issues if we have a chance to listen to what they say, and then come back to the sites authority to answer some of those questions. Or sort of bifurcate, have it 2 stages where we could bring the sites sites speakers back towards the end of the process, once other issues are for clarification, and to see whether or not some issues are really germane or not. I don't know if that's possible, but
that's, I'm thinking that through. It's typically we don't do that, where it would be like a bifurcated cross exam. You get, in a way, 2 chances at cross exam. But I can see the point that you have, which is particularly if there are other issues that come up that wouldn't necessarily come up in rebuttal, because the other answer is there will be a rebuttal, but rebuttal is limited to the witnesses that the authority would choose to bring on rebuttal. So
it's respective to the consultation, because the capacity, the tribes do not have much capacity. These are very complex, but to the extent that it may be a way to mitigate the consultation issues, and allowing the tribe to speak and then come back and see, because that is also the issue about, tribal ecological knowledge. It's a different perspective. And how do we actually respect that unless we actually have all the issues on the table? And so, it's especially where they haven't had a chance really, or a lot of people haven't had a chance to come and have the resources to engage us in a normal administrative hearing process. So I'll just leave it at that. But I think from point of equity and from a tribal consultation and the complexity of this, and to expect that this is going to impact the tribal cultural heritage and the Colusa County in general for hundreds of years in the future. Just from a point of efficiency, if that's possible. But anyhow.
Thank you, Mr. King. I think the way to deal with this, because we are right now, it's these are even more challenging procedural issues because we're speaking in the abstract, having not seen any of the testimony. Let's table this, but not in a forget about it sort of way. I think the way to deal with this will probably be on a case-by-case situation where we go through, we conduct cross-examination, and then if other issues come up, you or the representatives of the tribe, or if you have other questions, and then we can have exactly this conversation about why it would be appropriate to ask additional questions of the authority's witnesses. I think that then we'll have more clarity about exactly what the substance is and what we're talking about. But thank you for raising that potential issue. Mr. Busher.
Just one other thought on the ways to streamline the direct testimony, at least, and maybe more than that, the witness testimony, would be to separate out the presentations and the timing for the direct testimony until after the actual evidence has been disclosed and sites has indicated, right, these are the people we want to focus cross-examination on, or are going to spend more time with. Because, it may be a lot easier to condense that down, a month later than you finally finish your final report, having, also all the parties having the benefit of these are the witnesses that are going to be focused on, so that we don't spend a half an hour presenting direct testimony from somebody whose sites is not going to cross-examine based on their report. And so that may be the other way to do it, is to postpone the disclosure of the presentations and the timing of those, separate from the evidentiary reports themselves.
I think we're in agreement. Okay, so let's make sure I'm understanding you. What I was, and I didn't mention this, but what I was thinking is that I would, if we are going to take this approach where I set limitations on direct testimony summaries of direct testimony during the hearing after the July 1st deadline, then I should have a separate deadline for submission of those presentations so that you don't have to go through the exercise of creating a presentation that you're then not going to use, and that's or not allowed to use. So I was thinking that what we would do is we would have a deadline for the submission of cases in chief and the written testimony. Then we would set a deadline for any party to identify witnesses that they do not believe they intend to cross-examine based on the content of that written testimony. And then I would issue a procedural ruling identifying how much time each party or each witness will have for presentations of direct testimony. And then I will set a subsequent deadline for submitting the actual PowerPoint presentation, which should be within the scope of the written testimony. That was what I was thinking would be the full process. Does that fit with what you were proposing, Mr. Boucher?
Yeah, I think you said that clearer than I did, but that was the idea I was trying to go for.
Good, great. I think that would make sense.
So Ms. Kinsey,
yes, please.
Would that apply to the authorities' witnesses as well?
Everybody, it would be the same.
Okay.
I
guess I would
acknowledging that probably all of your witnesses will be cross-examined, so but maybe not.
Yeah, well, I think you said what I was going to request. We would certainly want to reserve the right to object to new testimony coming in through those PowerPoints that wasn't contained in the written testimony. And it seems like there could be some inefficiency there in terms of needing to review all those carefully to make sure there's not new testimony, but maybe it works out in the wash.
I think whether it comes, it's just you would have less time to do it. I mean, frankly, right? Either they come in July 1st or they come in. I would want to make sure you have enough time before the hearing starts to look at those, because that issue does come up in these proceedings where there appears to be a slide or something that it maybe wasn't within the scope.
Okay, thank you.
Thank you. I'm going to look to the room on this issue. Is there anyone else I'm going to scan because I have more than one page? But feel free to come off mute if anyone else would like to. Mr. Schutz, I see your hand up, please.
Yeah, in terms of, and this is not directly regarding the testimony, but in terms of efficiency and reducing the time of the proceeding, I think you mentioned at the previous pre-hearing conference, or maybe I just thought of it, the possibility that cross-examination might take place in groups or panels. Although it was not a short proceeding, I think in the water fix proceeding, that did somewhat shorten the amount of time it took for cross-examination. And also, I think it's often helpful substantively to be able to go back and forth between different witnesses, because what one witness says may be more in the realm of expertise of the other witness, and that issue can be pursued immediately rather than having to make a note and then pursue the issue when yet another witness comes up for cross-examination.
Thank you, Mr. Schutz. I think that is sometimes right, that the panels do add some efficiency. It did occur to me, especially when I was looking at the authorities witness list, there are a number of witnesses related to modeling. I don't know, without knowing more, whether those might appropriately be grouped into a panel for purposes of cross-examination. I don't know if you have any thoughts to add on this, Mr. Ferguson. I'm not sure it's something we don't need to resolve it today, but I think it is something we should continue to think about whether grouping witnesses in panels and what that would mean to explain if there are, let's say, 2 or 3 witnesses who are testifying to similar subject matter. And often I think we see it with modeling or with expert testimony where the testimony is interrelated. The 2 experts bring their expertise together, and they're really and they may submit a joint report with respect to their work. It sometimes makes sense for them to both summarize their direct testimony, their written testimony, and then are cross-examined as a group, if you were. So the question could go to either witness, or if there are 3 or more, any of the witnesses. And sometimes that adds to the efficiency, so you don't have to ask the same question of all 4 witnesses separately. That has worked in the past. Mr. Ferguson, do you have any immediate thoughts on that proposal?
Yeah, as we developed the witness list, we started to think about those groupings. And certainly are prepared to make a proposal for groupings when the time is right. So,
Okay.
and certainly around modeling is one area. Probably the water availability analysis is another area. I think on the fisheries side, we could certainly put some of those folks on together.
Mhm.
And then probably water quality too.
Great. That makes a lot of sense. I think the question then is when do we come to a final answer? But maybe what I propose, it sounds like there's room for agreement. Possibly, I know there are a lot of parties here, but if Mr. Ferguson, you're able to communicate with the parties and essentially meet and confer on this issue with your proposal, share your proposal and meet and confer. And then the next time we get together, we can confirm this. We do have our policy statement day. We already have on the books the policy statement day, which I believe is August 19th. I don't have it in front of me. Let me make sure I say that right so we don't get this confused. Yes, on August 19th, we have the hearing beginning with policy statements. What I would also like to do is use that day to the extent we don't have a completely full day. I think we can talk about some of the remaining procedural issues that day as well, and work out any final things before we get the hearing started. So I think that might be setting out. I could set an appropriate deadline beforehand to submit proposals, ideally proposals that may be agreed to by a number of the parties about groupings of witnesses. But we may want to do that soon. Well, let me think about that. If I'm going to set time limits for cross-exam, it may be helpful to have those groupings, but we can think about that. Mr. King, I see your hand is up, so I will turn to you.
I'll say on the water quality issues, I think it'd be great to have it as a grouping because the water quality in the sub-basin is also determines partly what flows in the delta. So I think I think there is some good reason to group the water quality testimony so that way, because it really is a watershed issue and integrated through from the watershed to the delta. So I think that'd be a good idea.
Thank you, Mr. King. Mr. Ferguson, did you still have a comment?
I was just thinking that it may be best to think about a deadline for proposing groupings after July 1st or
yes,
whatever it is established for submittal of the written testimony. Yeah. Okay.
That absolutely. We'll all know more once we see the testimony, a lot more. What I propose to do is move next to talk about this request from what I'm generally referring to. Oh, I'm sorry. Save California Salmon. I see a hand here.
Oh, hi. I just had a question related to grouping. Actually, two of the water quality experts asked if they could turn in their testimony together because their issues are so related that they feel like they would be better served to work on them together. And I just wasn't sure if that's allowable or not for two of the experts to turn in testimony at the same test or make their testimony as together.
This has been done. Thank you. It's a good question. I think the way to do it, and if there are others who have a better idea, I think the way to do it would be to submit something that might be you could submit joint testimony or a joint report, and then individual testimony to the individual signed by or it doesn't have to be signed, but will be attested to by the individual witnesses saying we worked together on this to that extent. But I think certainly that would be exactly an example where a panel for cross-examination really makes sense. So I think that would be the way to do it, would be to submit the joint testimony and then I don't know if it'd be an exhibit to the individual because that individual is going to attest only to their own part of that. But I think it's appropriate I can understand where the testimony is so interrelated, it doesn't make sense to submit it separately. Does that help? Did I sufficiently answer that?
Yeah, it actually explains it perfectly because even though their testimony will be submitted at once, their expertise are in different issues, but they're interrelated. So that's actually the perfect answer to give them. Thank you.
Thank you. So I wanted to move, I think I was going to move to this question about, there was a request to postpone the deadline for submission of case in chief evidence. I know there are also, I did read the pre-hearing conference statements. I know there are still concerns about the interplay of these proceedings and the update to the Bay Delta plan, and I've listened and heard to those. At this point, we're moving forward with the start of the hearing as proposed and the schedule as proposed for the case in chief portion, and then leaving aside how we want to address the remainder of that and when we will decide to get to rebuttal. That's still certainly an open question, but I just want to narrow the issue for our discussion right now. There is an outstanding request to postpone the deadline for submission of case in chief evidence to July 15th, but maintain all of the other deadlines. And I wanted to give the authority and any others a chance to respond. So I see your hand, Mr. King, but I think I'll turn first to Mr. Ferguson and then I'll turn to you, Mr. King.
Yeah, well, the authority objects to the request. I mean, the parties have certainly been aware of the deadline since at least April 18th, when you issued your revised hearing schedule. And, clearly that was already, the July 1st date's extended from the original May 24th date, which folks were aware of at the beginning of March. So at this point, an additional 2 weeks doesn't seem warranted. I guess I would also add, to the extent folks are claiming that it's necessary because the complicated nature of the issues, and there's a need to get up to speed. The authority certified its final EIR on November 17th, 2023, and adopted the project. And since at least that time, there's been a stable and definite project description and a host of analyses supporting that project available to the public. To the extent folks needed to review and get up to speed on those details, it's been out there for a number of months. So at this late date, it doesn't seem necessary to extend the deadline for those reasons.
Thank you, Mr. Ferguson. Mr. King, if you would
Yeah,
like.
so I would say, I appreciate those comments, but I have a lot of issues with the operations plan. I believe there are some material omissions. I would appreciate if the authority would respond to those, the omissions. I mean, there are several agreements that are in process that are germane, especially to the issues of water availability from the natural watershed from sites at Stone Corral, and how it all and the other participants from Glen Colusa to Colusa Drain Mutual Water Company, Colusa Basin Drainage District, the emission of RD 2047, all these things, and for the authority to submit an operations plan in May and expect us to be able to review that and understand that and be able to submit by July 1st, I think is unreasonable. But I think if we can have 15 more days, it's a good way. But also, I would appreciate if the authority would respond to emissions that respond to my pre-conference statement regarding the completeness and materiality of disclosure of the operations plan.
Thank you, Mr. King. And I think I saw Mr. Busher. I saw your hand, and then we'll go to Mr. Ornbaum.
I was going to go ahead and defer to Mr. Ornbaum.
Okay, Mr. Ornbaum. And you do need to click off mute. I think sometimes the space bar works for that if you're on a computer. Well, you may be on, Mr. Busher. Go ahead.
Thank you. So I don't want to reiterate kind of what we put in the brief, but I think it's clear from the discussion already today and clear from the discussion we had at the last pre-hearing conference that the short deadlines here and the complexity of this project and the interrelationships between this project and a whole bunch of other ongoing water rights and water related proceedings have made public participation and especially tribal participation difficult. And we think there is good reason to allow for that extra 2 weeks to see if that alleviates some of those burdens. And I don't think that changing that deadline from July 1 to July 15 is going to impact any of the remaining scheduled dates that we've got right now. And I'll defer to what those scheduled dates are going to be when we get to the conversation about the hearing dates and their schedules. But I think we can, extend that deadline, allow for the additional time to maximize the ability of the tribal and NGO interests to participate and to prepare that evidence without interfering with the ultimate timeline for this project. And then the last thing I'll say is that, right, even if the case in chief deadlines slip a little bit, we don't have, right, rebuttal evidence scheduled yet. And I think it's unlikely that 2 weeks here is going to change the ultimate date on which this entire proceeding is completed.
Thank you, Mr. Busher. Mr. Ornbaum, I wanted to turn again to you to see if we can get you off mute, and because I would like to hear from you. And I'll give you a standing invitation when you come off mute to go ahead and chime in. With that, I will turn to you, Mr. Mooney.
Yeah, I would agree with what Mr. Busher had stated, and also indicate in responding to Mr. Ferguson that they've had their experts working on this for years, and we've had our experts working on this for a couple of months. And again, 2 weeks is not, we're not asking the schedule to be pushed back, but giving us an additional couple of weeks will just provide a better quality hearing, I believe.
Thank you, Mr. Mooney. And Ms. Chicazola.
Hi, I wanted to echo what was just said, but also bring up the point that for some of our experts, seeing an operations plan is critical, especially to the issues of water quality. And I don't think we have an ITP to this date. So I do, and I also want to bring up that Sites has had the benefit of having a massive amount of public funding to help with both the creation of their environmental documents and for their experts. And still it took this long to get to an operations plan. So to ask for an extra couple of weeks, I don't see that holding up the project very much, but it will help us immensely, especially with the issues of fisheries impacts and things such as going over the operations plan to really determine what the impacts to water quality are. I mean, some of the issues are not changed by the operation plans, but some of them really are, and I'd like the time to review that. And I know it's been out for a little while, but we have a couple of employees in our organization and we don't get the level of public funding or support that the Sites Authority does. So a couple weeks is very helpful to us.
Thank you. I appreciate that comment. And Mr. Ornbaum, I think I saw you were able to come off mute.
Yes, thank you. On the giving it more time, like into July there, I think Mr. Ferguson, hasn't the Sites Authority changed their permit process a little bit? I mean, their initial permit, you've made adjustments and changes, since the beginning until now. I think that's reasonable reason for giving us a little bit more time to have a final say, like in the 1st of July.
Thank you, Mr. Ornbaum. And I will turn to you, Mr. Ferguson, and then Mr. Reese, unless you'd like to go in reverse order.
Yeah, maybe it'd be best to go in reverse order.
Okay,
Yeah.
Mr. Reese.
Thank you. Our request was that it's premature, which I know that you're moving forward with the process, but at least the extra 2 weeks. And I was going to request 30 days, but at least the extra 2 weeks. It doesn't condense it too much. It doesn't affect the later still to be determined phases in terms of date setting. And it still leaves plenty of time between submittal and the commencement of the hearing. So I would echo the other comments and at least request the extra 2 weeks for the case in chiefs, which I think will help make the written testimony more efficient and streamlined.
Thank you. It does fit with my general sense, which is if I want, usually, right, if you want shorter briefs, you have to give the attorneys more time. This may be a similar principle. But Mr. Ferguson, go ahead.
Yeah, I just wanted to make a comment about the scope of the operations agreement. As folks could see, if they compare the content there to what's in the EIR, it's essentially a centralization and a compilation of operations details that were contained in the EIR, and the authority has put them in one place. So again, that material has been out there for an extensive amount of time. The authority's compiled it one place. Folks now have a chance to efficiently review it. To the extent there are things yet to be done that are identified in the operations agreement, like securing access to certain rediversion facilities or executing facility use agreements for those points of rediversion. Those items do not need to be wrapped up at this time in order for it to be a complete and effective operations agreement. I mean, the document clearly describes how sites is going to divert, store, and release water for beneficial use. And that's enough at this point in time for the board to issue a water right permit. And so I just want to be clear that this additional 2 weeks is not going to result in the authority putting any additional content or secure it into that plan or securing any additional agreements. The authority doesn't believe any of that's necessary at this point. And has provided sufficient information for folks to understand the operations to the extent necessary to issue the permit. And I just want to make a couple of comments about the tribal interests and the need for additional time to accommodate the tribes. I mean no disrespect here, but it's interesting that the tribes aren't participating today, at least not directly, yet many folks have represented that it's critical that they need more time and they don't have the capacity to or time to engage in the process. It's interesting that they're not here raising those issues and raising those claims. So I guess take that for what you will. I find it interesting that they're not here if it's really that important.
Thank you, Mr. Ferguson. I do have one follow-up. I think we might as well address it now because the operations plan has come up. Just for my clarification, I think when I read your pre-hearing conference statement, my understanding was that the final agreements with DWR and the Bureau in terms of operations are intended to be completed after issuance of the permit, that the intended order is that any water right permit that the board approves would come first, and then those agreements will be finalized. Do I have a correct understanding generally of the anticipated timeline?
Yeah, so we're talking about different agreements.
Okay.
The operations or the agreements with, for example, reclamation is a partnership agreement, which is similar to the storage agreement that the other storage partners are going to execute. And that would be executed at a later date.
Okay.
Or around the time that all storage partners would be executing those agreements. The kind of agreements I had in mind are referenced in the operations plan, and it's agreements that need to be in place for the members to ultimately receive water in their places of use. And I believe these are going to be primarily downstream at certain points of rediversion along for example, the project facilities in order to get members their water. That's what I had in mind when I mentioned agreement.
Okay, thank you. That's helpful. Thank you. I'll turn back to Mr. Ornbaum. Did you have something else to add? And if you don't, that's okay. Just lower your hand, your virtual hand.
Oh,
but you're
yes.
welcome to speak if you have something.
Question for Mr. Ferguson. That'd help me understand if you have all that math figured out. That's part of my process. I want to understand of our Colusa County watershed, how much is received, how much is divvied out to initial water rights that are already there first, and how much is left over. I've met 3 times, with the sites authority people, and I have a hard time coming up with that number. It's a moving number. I would sure like to see the math like written down. I show them my math, but they don't show me theirs. Would you be able to help me with that directly?
Well, let me intervene with that. I mean, certainly, Mr. Ornbaum, you're more than welcome to have conversations with the authority and Mr. Ferguson. But I just want to point out in terms of this hearing process, first of all, you'll get the written testimony, which is the authorities actually their case on how this is going to work, right? And then you will have the chance to cross-examine their witnesses. So I think you will have the chance to directly ask the individuals who may have knowledge about this, about exactly the substance of what you've raised here. with that, Mr. Ferguson, did you want to respond any further? No.
No.
Mr. Ornbaum, did you have other thing? I didn't mean to stop
Yeah,
the
yeah,
conversation.
it would help me. Maybe we're on the same page already. If I understood that math, it would be a much shorter version. If I understood and agreed with that math, I'd be fine.
Thank you. That's helpful. It sounds like maybe there's room for an additional, I know it sounds like you've had some conversations and I'm glad to hear that, but an additional conversation may be helpful. And then there's also this hearing process. So thank you, Mr. Ornbaum. Mr. King, please.
Second, here we go. Regarding the operations plan, the operations plan is foundational to the state's water right, whether or not they can sign it, and that we have one source of water in the Funk's Reservoir that's not addressed. The other issue is in the operations plan, you're assuming authority and a scope of authority just doesn't exist. The Coosa, you're going to enter into agreement with the Coosa Drain Mutual Water Company, and you're assuming that they have authority over the lands that are used that actually encompass the Coosa Basin Drain, which they don't. There are several issues that you're basically ascribing authority to that don't.
So,
You're also entertaining.
Mr. King, thank you. This is substantive discussion. I know a lot of your pre-hearing conference statement too was also very substantive. This is exactly what bring this in your if you plan to submit testimony, if you're planning to submit exhibits on the case in chief for your cross-examination, for your closing briefs, all of that is the appropriate place. I do want to stay. I know you're making a point here that the operation plan is critical to your understanding of how this project will work and how you can put on your case. And I do understand that and appreciate that. I just want to keep us focused on procedure here and also assure everyone that there is certainly a chance to make all of your substantive arguments. That's exactly what this hearing process is for. So thank you for that. Is there anything, I don't want to cut you off. Are there procedural issues that you'd like to raise? Okay, thank you. Ms. Meserve.
Thank you. OSHA Meserve for San Joaquin County. I guess with respect to the request for a small extension on the case in chief, I understand that the materials have been out for a while, and for those folks who've been following it, and they may have a detailed understanding of the proposed project or application, but the experts were more recently obtained or retained, right? And so that's just been in the last, couple of months for most of us. And so we're in the process of trying to catch our experts up with where all the information is, and they're having a lot of questions. I know I'm working on fisheries issues, so it's not, I think it would be wrong to assume that all the material's been sitting out there and that, why haven't our experts started writing on it? Like we've been kind of doing things in order and when things are clear about when the deadlines are. And I guess I'm just finding that it's a lot more difficult to get our experts up to speed on what the facts of the project are that they are supposed to be responding to for purposes of testimony than one might expect, or maybe you would expect it with a project, this large and extensive, and the diagrams aren't great, with how, how the water goes out and in and where, so there's a lot of questions coming up. So, we're trying to get the experts the information they need to make useful testimony, but I think that's the reason why, as a fallback on waiting for the water quality control plan, which we understand is not going to happen at this time. I think that's why we're asking for just a slight bump in time just to get those experts the info they need.
Thank you, Ms. Meserve. And Castle Willie with Save California Salmon.
Yes, hi, this is Cassil Willie, staff attorney for Save California Salmon. I just wanted to respond to a comment that was made by Mr. Ferguson that was really just inappropriate regarding if tribes were so interested, then they would be here. It is very well known that tribes and tribal governments are severely understaffed. And with so many things going on within their own organizations, showing up to every single meeting is not always possible. And luckily, they have many allies on this call and in this hearing that are able to speak up for them here today. And saying that if they wanted to be here, they would is just very insulting and disappointing to hear. Thank you.
Thank you. I want to just add here. I know we're all the attorneys are here to make their arguments on behalf of their client, and that's important. And it is we have a difficult situation when you have parties who do not have the resources to participate, but then there's this gap, right? So thank you for the opportunity to address this. I wanted to bring up, for those who are listening, who may be communicating with members of any organization who just aren't able to make this conference today. We do have a pro bono list on the AHO website of attorneys and law firms who have volunteered when appropriate to potentially represent parties in AHO proceedings pro bono. So there are some possibly resources there. You're not required to have an attorney to participate in AHO proceedings, as you know, but it may be helpful to have someone whose job it is to be here for these kinds of conversations and to represent the parties and understand the procedures. So I really want to emphasize that if there's a way to get that information over to anyone who was not able to make the call, or anyone who's on the call and you're not represented by an attorney, we do have a list available. And I encourage you as soon as possible, if you have an interest, to reach out to those who are identified on our list, because that may assist. It's a better process all around if everyone is represented and has the chance to fully participate. So I think everyone agrees with that, and I appreciate that. Mr. King, please.
Yeah, so I think this process has been transformative to me regarding tribal rights and equity around that. And I encourage Mr. Ferguson actually to read Peter Burnett's address to state legislature in 1851. And you can see the perspective and one reason why I brought the issue about why the tribes basically were duped to give up City Colusa in exchange for land on the east side. And one of the points that Governor Burnett actually said is that for Europeans, time is money. But and he actually goes in the perspective of the indigenous tribes, the people that were there, and how they look at things differently. And I would encourage them to actually read that statement, because as you know, as this process, we're talking about actually allocating or reassigning a right that's owned by the people of California, and we have executive order, and we have a lot of policy to respect tribal rights and equity generally, and it's really informative to the conditions from which the tribes are in their situation. And I've been transformed by this process. So I grew up in Colusa. I didn't understand what actually happened, but actually being engaged in water issues, this process has given me a new perspective on things. And I would encourage Mr. Ferguson to actually participate in that also. Thank you.
Thank you. And Ms. Chicazola.
Oh, yes. I also took issue with Mr. Ferguson's comment, but part of that is because Winnemem-Wintu tribe was on our water rights protest. And I think they are being represented here because they're on our water rights protest, and they're also on Water Climate Trust's water rights protest. So if they need to come separately and they're not aware they need to come separately, then that's an issue that we need to let them know, because there's groupings, and I heard it said that Water Climate Trust at all, and I know that that's the same situation with a lot of these protests where there's one person representing a whole group, and I think that's what Winnemem-Wintu expects that's happening here. And it is kind of confusing that some people are on a protest and are covered by the attorney for that protest, and some people are not. And I just think that if they need to be here separately with their own attorney, they're not aware of that. They think that they are being covered within this proceedings. So I just wanted to mention that real quickly. I can't speak for any of the other tribes, but I do know that people did expect to be consulted through a government-to-government style consultation. And I think sites really fell down on that. And they also fell down on negotiations when it comes to tribes that do have established water rights. So that's obviously not on you, but being that so many tribes have complained about the way that they did consultation, that statement does seem disingenuous. And yeah, let us know if we need to tell Winnemem-Wintu tribe that they're not being covered at all with everyone else in these proceedings. So
Thank you. This sounds like there may be a really important issue here, because my understanding is that no attorney or representative here claims to or is asserting to represent any of the tribes explicitly, although I understand they are signatories to the protests and are, have raised those issues and signed on to the, as I understand, the common witness list. So I don't want to say that they need to be represented by an attorney separately. But that sounds like there needs to be some clarification. I don't want the tribes to be in a situation where they think an attorney or other representative is acting on their behalf, and that's not the case. That's a conversation I think that needs to please have that occur separately outside of this proceeding, and I'll check in on it. But that is a significant concern if there's confusion about representation. We want that to be very clear, and that's why, at least for attorneys, we have an ethical obligation to have a written agreement with any client so that these representation issues are very, very clear and there's not confusion. So for those who are listening, I'm concerned, and please check in with the tribes. If they're a signatory to your protest, I think it would be a good idea to have a conversation about the scope of that coordination. Mr. Schutz, I will turn to you.
I think Mr. Ferguson may want to respond on the tribal issue. I had something that deals
Separate.
generally with the witness list, so
Okay.
perhaps it would be best to hear him first.
Thank you. Mr. Ferguson. You're on mute, I'm sorry.
I certainly meant no disrespect, and as you could tell, I even hesitated to say that because I understand the sensitivity, but it was more to your point, Ms. Kinsey. It wasn't clear to me that certain parties that were raising the tribal issue as a basis for providing more time were actually even representing tribal interests. For example, I don't think Mr. Busher, he mentioned tribes, but so that was more my point, is a number of folks seem to be identifying the tribal interests as a reason for the postponement, but it wasn't clear to me that there was anybody here actually representing their interests. So, and I thought that said something about the importance. And particularly since one of the NGO witness lists, I think, has 12 potential witnesses to deal with tribal issues. I mean, that's just an example. There clearly are resources and potential representatives out there, and yet they're not here. So.
Thank you, Mr. Ferguson. I hesitate to, I think we all, I think we've laid out our your respective positions on this, but before I turn to Mr. Schutz on a specific issue, is there more on these issues that we've already talked about? And this is not the last call. We have more things to address. We will take a break shortly, but I'll turn to you, Mr. Schutz.
Thank you. Listening to Mr. King speak today, and his bringing up substantive issues that, as you pointed out, Ms. Kinsey, might be more appropriately part of the hearing itself. And considering that Mr. King's witness was duplicative of the authority, and he's left now without a witness and a case in chief, it seems like it might be appropriate to allow him, if he wishes, to submit himself as a witness, even though witness lists have already been presented, given the fact that there was this conflict, because it does seem like he has significant information that other parties that I have heard from have not yet put forward, either specifically or just generally in terms of the subject matter that he's wishing to raise. So I think that would be between you and Mr. King, but I wouldn't want him to feel that his perspective was excluded because of this procedural conflict. Thank you.
Thank you. I think I will turn to you, Mr. King. Would you like to respond?
Yeah, well, I appreciate that. As you say, I do have appreciation for litigation. I don't have experience in litigation. But I think that'd be I appreciate the opportunity of that. And also I haven't talked to Mr. Ornbon about that, but Mr. Ornbon has great expertise around groundwater and the groundwater resources, especially in the area south of Davis Weir around Sycamore Slough. And I think if both Mr. Ornbon and myself, of course, within the confines of time limits, had a chance to actually present our expertise. My family's been farming on the Coosa Trough since 1860. Mr. Ornbon's family has been there forever too, and is now currently a farmer. That I think it would raise a lot of substantive issues that other people could see if they were germane or not. So I appreciate that from Mr. Schutz. I would welcome the opportunity if Presiding Officer Kenzie thought that was appropriate. Thank you.
I think what I'll do, and I will hear from you, Mr. Ferguson, the next step I think is, and you can testify as an individual, as a witness, and Mr. Ornbound can as well. You certainly can submit written testimony and would, in many ways, I think it could be very relevant here, and helpful. That does, just so you're fully aware, that opens you up for cross-examination with respect to any relevant issue within the scope of the hearing. I mean, you're not going to be cross-examined on things outside of the scope. I just want to make you aware of that. And then I think the way to do this, because the witness deadline was the 12th, would be for you and Mr. Ornbound and anyone else who wants to submit or identify new witnesses to submit a request or a motion, if you want to call it formally a motion, and that any opposing party would have a chance to respond then, and then I would make a decision. I'm not going to make a decision here. I would want to hear all sides of this, but support as to why that particular witness, you think their testimony would be relevant and important, would be important information to support any request like that. And that could be done by email with, of course, CC to the service list. And then I would allow some time for others to respond. So I will turn to you, Mr. Ferguson. Do you have comments about this or that process of how to deal with essentially a late request to identify a witness? And you are still on mute.
Having trouble this morning. Yeah, we object to that request now. Mr. King understood the deadline was June 12th. He got his witness list in on time, understanding that was the deadline. And it wasn't a matter of duplication. Mr. King hadn't communicated with Mr. Davids and simply put him on his list. So it was, Mr. King's choice to do it that way, and he missed the deadline. And he was certainly familiar with the rules again. So we'll certainly, if you decide to proceed with the process you described, we'll certainly take a look at that and file an appropriate response. But as of now, we would object to that request for both Mr. King and Mr. Ornbon.
Thank you. So I think I will say I will follow the procedures I laid out. I will ask Mr. King or Mr. Ornbound or anyone else who would like to identify a witness and file a motion or request to do that, to file it by the end of the week, this week, because we are coming up on important deadlines, and I want to move this forward. So this is the 17th. If you could file those requests, would file those requests by the end of the day. And when I say end of the day, I always mean the end of the actual day. We used to do 5 p.m., but with electronic service, it's midnight. End of the day on the 21st. That's this Friday, I believe. And then I will allow a few days for folks to respond to that request. It does mean, yeah. So let's go, and then I'll allow until the 28th to respond to requests. And then I will rule on that quickly. We're going to talk about, I realize that puts you in the situation, Mr. King, of possibly preparing testimony to be in on July 1st. If that deadline doesn't change, I'm not going to rule on that issue today. But I think given the situation, I want to do this fairly. It may make sense.
I'll reach out to Mr. Ornbaum and see if he's even amenable to that. Yeah. But thank you so much. Thank you for that consideration. Yeah.
I'm looking at taking a break, but there's anything else that we should talk about related to these, what we've talked about so far. What my thought is, we'll take a break, we'll come back, and I think want to wrap up the schedule discussion. We have a few more things. I mean, I think we can explicitly talk about rebuttal, although I think I've already quite foreshadowed that we're going forward with the case in chief portion of the hearing, but I will open up to, so we, if there are other things to add to that. And then we'll move forward to a discussion about the site visit and go from there. But is there anything else we should talk about before we take, I just want to do a 5-minute break. All right. Seeing none, let us return at, let's say, 10:42 on my clock. I see 10:36, we'll do 10:42. I will see you in a few minutes. Thank you. All right, I'll just give the oral alert that I'll get started here in just a few seconds. All right, let's go back on the record. It's 10:42. We took a 5 or 6 minute break. I wanted to return just for a few things on the schedule and then talking about the site visit. In terms of the schedule, I did want to clarify with respect to the ITPs. I believe it was in the authority's pre-hearing conference statement, although I may have that wrong. But I believe there was a suggestion that the AHO wants the ITPs in hand before we schedule a rebuttal, and that's not necessarily what I'm thinking. I just know that these processes, when we have simultaneous all these processes going on at the same time, and you all, I think, are just as aware of it as I am. And as we move forward, hopefully there will be more clarity about when these anticipated events are going to actually occur. It sounds like, Mr. Ferguson, I read your statement, and hopefully you're here somewhere.
I'm here.
You're back. Okay, good. I just want to make sure I wasn't running off without you returning. It sounds like, as far as you know, CDFW is on track to make that October release of the ITP, which would put us in a situation to proceed with rebuttal. But sometimes these things change. So really my intent is to revisit the scheduling of rebuttal. I want to get it on the schedule soon enough so we all have time and you know how to plan your lives, and both personal and professional, and how these things are going to go. But at the same time, acknowledging that right now there just seem to be so many proceedings going at once. It's really, I don't know what would be the most appropriate. And to be perfectly frank, we have of course, the Delta Plan update. That's a simultaneous process. And we can't talk about it in any controversial or substantive way, but the Delta conveyance proceeding is out there too. And I know many of you will be parties to both. So looking at all those things, the decision not to explicitly include rebuttal schedule in the hearing notice is just an acknowledgement that it's very unclear at this point. We need to revisit this regularly, and as soon as there is some clarity about how it makes sense to go forward, I want to put a schedule in place so that we all are on notice. But that's the thinking behind not explicitly scheduling rebuttal, is that there's a good chance that we would have to change those dates in any case. And I don't want to go through, it didn't make sense to me to go through this exercise where we schedule dates and then knowing that they're pretend or something. Not saying that they can't, we may in fact go forward with a schedule very similar to what we issued in April. So I wanted to put that out there. On that, is there anyone who wants to make any additional comments on that, or if there are questions, or I know that doesn't add clarity, but I wanted to, well, hopefully it adds clarity about what the thinking was behind not including a rebuttal schedule. Are there any comments? And then next we'll go to the site visit.
Well, if you don't mind, Ms. Kinsey, it was stated in the pre-hearing conference letter, but the authority, and I'm sure everybody else recognizes there's likely to be other issues to address on rebuttal besides the ITPs. And so it seemed reasonable to continue with the schedule, knowing that there's going to need to be a need to have some rebuttal and cross-examination of those witnesses on those other issues regardless. So, and so we think that's a good reason to at least have it on the calendar. And the authority is pretty confident. I mean, they've been engaging with CDFW regularly, and again, have confirmed with them since the last pre-hearing conference that, and CDFW has indicated that the ITP is for both construction and operation will likely be out no later than mid-October. So we think you could confidently schedule those dates and have plenty of substantive testimony to go over at that time, even now. So
thank you, Mr. Ferguson. Understood, and I think your point was also well laid out in your pre-hearing conference statement as well. So thank you. Are there any other comments?
Ms. Kenzie, this is Eric Busher from Baykeeper.
Yes, please.
I just wanted to make sure I heard you correctly right before the break. You said you're not going to issue a decision today on the case in chief evidence deadline, whether that July 1 date would move. And we would just request that
Some clarity about when
you do your best to issue a decision quickly. I recognize you are busy like the rest of us, but just so that we have as much notice as we can before whenever that deadline is going to be.
Absolutely. And thank you for that, because I did intend to provide some assurances, which is my intent would be to get something like an email, that would give you it's moving, it's not moving, either tomorrow or at latest Wednesday morning, because I realize those deadlines are very rapidly approaching, and you all need to have some clarity about whether you're aiming at July 1st or not. So I will make that commitment.
Thank you.
I will try to also, a written form, I shouldn't say written, a more formal ruling may come a little after, but an email communication, something so all of you are aware, will come out tomorrow or the next day. All right, let's talk about the site visit. I think first we should talk about the date, and then we can talk about, or maybe we talk about it all at once. Let's talk about it all at once, both the date and procedures. Mr. Schutz, did you want to jump in?
Yeah, just to follow up on that, okay. If you would be kind enough to also indicate, you discussed earlier regarding the summary of testimony PowerPoints kind of thing, if you could cover that in whatever email you are able to send out.
Yes.
I think that would also be helpful. Thank you.
Yes, that I will cover as much as I can in that email to give you clarity. Okay, thank you. So on this site visit, I think I know it was relatively short notice where I laid out the procedures. First of all, you did notice that the change from what the initial proposal was for the site visit, August 21st and 22nd, which was in the April issuance, I believe. It didn't work for Mr. King, and it's important to me that Mr. King be involved in the site visit. And I think he had very good reasons about why he needed to be somewhere else. So I do want to work around Mr. King's schedule in that respect. So I'd like to think collectively about when it makes sense to conduct the site visit. I put out 2 days because it's my understanding that there's a lot. I did talk to some other staff who had been on similar site visits, and the consensus seemed to be that there's a lot to see potentially, depending on the itinerary. So I thought it made sense to stake out 2 days with it may be possible that later we want to go out again. I want to be efficient with everyone's time. I want to be efficient with staff time. But of course, there's nothing like seeing the actual topography and the facilities where they're present in person. So I want to talk about date, and then I also wanted to talk about procedures. I think the authority had some helpful comments about how this might go. I want to talk through them. Some of the things you raised, Mr. Ferguson, were about how the commenters how the substance of the comments, if we can put it that way, would be treated. Would it be testimony? Would it be evidentiary testimony? And would they be subject to cross-examination as a result? I'd like to talk through that because, of course, I want to make sure that we get that the evidentiary value is there, that it's something that we can rely on, but also that we have an equitable process if there is a dispute. I mean, hopefully pointing out certain features won't be disputed, but I want to be prepared for that possibility. I also wanted to clarify that my suggestion, I think previously I'd suggested we'd have everything fully scripted in advance, and I'd thought about that. That seems, on second thought, that seems challenging, and it seems like it may result in a lot of back and forth before the site visit itself. So what I was thinking now, and what I tried to convey and maybe did it inartfully, was that the subject matter, the general scope of the comments would be identified, like so-and-so is going to point out these features of the facility, but it wouldn't necessarily be a verbatim scripted kind of thing, but that we would all know in advance what each commenter was planning to comment about and point out, so that there aren't surprises. So I think with those two things or several things about date and process on the table, I'll turn first to you, Mr. Ferguson, if you have any reactions, and then I'll turn to the room. But a big question is, if we can't do August 21st and 22nd, what's the next best? And we can ask, I don't know if it makes sense to hear from Mr. King about his availability too, and others, but I'll look to you first, Mr. Ferguson.
Well, in terms of the dates, you'd identified September 9th and 10th as the next possible dates. I think the authority can make those work as of now.
Okay.
And I would say you had a question maybe about how many days might be necessary. And I will say 2 days is probably a good to set aside. It's just geographically so spread out from Red Bluff to the Knights Landing outfall gates, really, and to the Sacramento River, and there's a lot to see. So at least 2 days sounds good. As far as the approach, I mean, we appreciate the idea of it maybe not being entirely scripted. That seems like it would be pretty challenging and maybe a little awkward. So we can certainly prepare bulleted comments about topics. I think you'd also suggested possibly recording.
Yes.
And I thought that might be a way to address this concern about maybe not everybody being there, maybe not everybody hearing what everybody says or knowing what everybody has said. And that might help if we can come up with a way to effectively make that recording. I think that could address that potential risk of certain folks not hearing what was said. So I think that's a good idea.
Yes, and I will make that commitment if it sounds like we are going to do a site visit. We have the AHO has done site visits before. We've always recorded them. We have an AHO GoPro for this purpose.
Okay.
So we have my team has worked through the logistics of how do you do this exactly? But our intent would be to fully record it. The visual sometimes you can see who the speaker is. In addition, if there are features pointed out, we would attempt to take photographs of the features as they're pointed out. And all of those things would be made part of the record so that everybody has a chance to review them and as appropriate respond if there are things that come up that need clarity. So that would be a commitment.
Okay, great.
Back to you, Mr. Ferguson, if you have more you'd like to.
Yeah, thanks. I just wanted to clarify the comment in the pre-hearing conference statement which I described as an exception to your general approach. And that has to do with persons that we would anticipate would be present, for example, at the GCID fish screen. GCID has its own operators that are well-versed in describing the operation and describing what folks are seeing, but we haven't identified those people as witnesses in the water right proceedings. So we'd anticipated that they could be present and make helpful comments about the facilities. But then we didn't expect that they would be subject to cross-examination after doing so. And I will say they're going to provide some helpful context. The authority is still, for example, the authority is still going to have witnesses that are going to describe the facilities that are going to be used. And those witnesses can certainly, they will be subject to cross-examination. So to the extent there's any concern about not being able to ask your questions about what we're going to see, I don't think that's going to be an issue because we should have witnesses that would be able to speak to all the facilities we're going to see.
I think, and I want to continue, I have a feeling others will want to chime in on this, but I'm trying to wrap my mind around what I think, it really is a witness offering, or I won't call him, someone offering testimony, right? To point out something, a feature, or discuss something, is offering, I believe, testimony, but then they would not be subject to cross-examination. Now, I can understand limiting the scope of cross to the content of their comments. That would make sense to me. But I'm just, I don't, I have concerns. Do you want to address that more, Mr. Ferguson? Now, I'll also give you a chance when we hear from others. But I'll be honest, that is a concern I have.
Well, I guess I would suggest that their comments don't need to be treated as testimony. And that Sites is not putting forth their comments as direct testimony for its case. And so in that regard, we have no concern if you don't rely on it as testimony. Because again, the authority is going to have witnesses, which is identified on his witness list, that will speak to these facilities and their operations. And that's the testimony that Sites proposes to be in the record to support its case.
Okay, let me, thank you, Mr. Ferguson. Let me go around the room because others may help me expand on this concept, but I'll turn to you, Mr. King. Thank you. Please go ahead. There you go.
Yes, thank you. So first of all, thank you for the change in the schedule. My daughter is going to be opening the dorms on August 22nd in Wesley, Mass. So she's a high school graduate, and it's my job to take her. So I appreciate you changing the schedule, and the schedule as I believe you propose is fine with me. So thank you for that. Regarding the site visits and the cross-examination, the issue really is whether or not there's available water and the quality of that water. And I believe this is the problem with the authority's application, is that it's relying on these other existing infrastructures and other parties, but only wants to talk about the externalities of the extra part of it, the marginal part that this reservoir will do, without actually looking at how it's going to impact the water flows and the quality of water. And if a GCID employee is, of course, going to say what GCID wants them to say, and GCID is going to say what Sites wants them to say, because interrelationships and they're members of that. And without cross-examination, I don't know how you as the water board and representing the laws and regulations of policy state of California and actually can come up with a conclusion. I think this is, I don't know if it's intended or not, but the strategy is like, oh, it's not, we have no authority, we don't have no control over that, we don't control that. But at the end of the day, they're relying on all the existing infrastructure and stuff. And so that's why also regarding the Sites visits, I would like to show the board my diversion sites, but also the reason why there's not a water availability during the period of diversion. Even this year, there has not water available this diversion, and show you the operation, how the Davis Weir Dam and then the Maxwell Irrigation District Dam, and those sites. And I also think we also need to see Funk's Reservoir and how water flows into that. So those are reasons why I propose that. But at the end of the day, you're going to make a decision based off of the laws and regulations, policy state of California. I don't think we should be afraid of having cross-examination of anybody on this, because at the end of the day, it's going to be yours. So let's let all the facts come out, and then we'll figure out what you'll make it. Because this discussion is going to be germane to the terms that you're going to make for the application. And also, it should be informative even to the California Water Commission and how they allocate, the Prop 1 funds to this. These are all about policies of the state of California, and you as an agency of that to implement that. So thank you.
Thank you, Mr. King. And I think that raises a point that I tried to convey in the procedures outlined for the site visit, but I think did not directly address now, which is my vision for the site visit is that comments would be very limited, not because additional comments and testimony about these facilities aren't important, but because those should be in the hearing where there's cross-examination and through that formal process. My vision of the site visit is that the comments would be very limited to, this is what you're looking at. These are the features. And that any substantive testimony in terms other than this is what you're looking at would be reserved for the virtual hearing room, if you will. And certainly there would be cross-examined on those issues. But so we're talking about a narrow type of comment. Nonetheless, I just anticipate that there may be disagreement about the way certain things are characterized, even in just pointing them out. I mean, hopefully that may not be true, but I just want to think about this in advance. And maybe, Mr. Ferguson, I hear what you're saying in terms of that the comments themselves may not have evidentiary value, but I'm trying to wrap my mind around that one. Are there other comments from any of the other parties about the site visit, either the dates, the procedures? I would look to all of you to have a meet and confer about where we should go. I'm not going to put out where I want to go because I don't know. You tell me. It may come up later. I mean, if we end up needing another site visit, then I would have an idea about where I'd like to go. If there, something comes out in the cases in chief or in other contexts, but I would look to all of you to come to some agreement about what we can accomplish in 2 days and where the relevant locations are. With that, Mr. Schutz, please.
Yes, I'm not going to opine on the evidentiary question. I just think it's good background to consider the kinds of things that come up on site visits. Someone presents something, sort of describes the general operation of different facilities. There are often clarifying questions that come up that are not comments, but that are not things that are sort of affirmatively volunteered in the initial discussion by the person conducting the site visit. For example, what's the period of maintenance for this kind of facility? What are some of the seasonal constraints, if any, that you have, that the physical characteristics of the facility may have? Those kind of things are not necessarily editorial or just go more to the factual background of what you're looking at. And sometimes those questions are helpful in order to better understand the facility, especially for those who are not familiar with it. So somehow I would request that kind of issue be considered as you're considering the greater question of evidence and cross-examination. Also, a lot of these facilities are very loud, and I don't know what your idea might be for what the venue for cross-examination would be. But with a lot of, with 30, 20, 60, I don't know how many people standing around, it could be difficult just in practical terms to effectively conduct examination right there in the on site. However, in the absence of the physical structure, if you were to go off into another building or something like that, you might not be able to ask the same question. So those are some things I request that you think about.
Thank you. It is a challenge. And certainly I agree that part of thinking this through is thinking about how to limit discussion during the site visit, in part because we have to get to all the places, but without limiting the opportunity to ask appropriate questions and get to some clarity. Mr. Ferguson, back to you. You are still on mute.
I would only anticipate persons that the authority has not identified as witnesses at a few locations. I still would anticipate that some of the authority witnesses would be on the tour and would be providing some comments. For example, Ms. Forsyth, we've identified J.P. Robinette to talk about facilities and some of the engineering features. So Mr. Robinette, I could see him being on the tour and possibly providing comments. I just wanted to be clear that that wasn't going to be the entire set of comments, and as far as people who are not identified on our witness list, it would just be I think just at a few of the facilities where this issue would be relevant.
Thank you, Mr. Ferguson. And I can understand that in some cases, the person with the most knowledge would be the operator who was not otherwise identified. So I think I understand the.
If I might just ask a question too to Mr. Schutz's comments, well, it sounds like you're going to give some thought to the issue of questions of the person making the comments and whether that's even going to be allowed. So
that is, and as we're talking this through, I'll be transparent. I'm wondering if questions, I will reserve the opportunity to ask questions. I might ask questions. We may have a board member join us on the site visit. That person may ask questions. But whether or not other parties should be permitted to ask questions on the spot, I don't know. And that's why that's part of this, is that if there isn't an opportunity to ask questions on the spot, then how do we deal with that issue later? We will have this video recording, so it's not the same as being there, but if we were all there, at least we will have a video and hopefully, or photographs of the features, and we can maybe refresh our recollection of what it actually looked like when we were standing there. And have an opportunity to ask questions. But yes, I am trying to think this through as to how that all might work. It's a big group. We've done site visits before, but not with such a big group, of course, and not with such complex facilities. But because of the complexity, it seems particularly important. It sounds to me like September 9th and 10th, that there are no serious, I don't want to say serious, but that is, I've not heard any objections to those dates, other than it's a little awkward to run the site visit partway through the case in chief, but I think that's somewhat unavoidable here. I didn't want to schedule it right before Labor Day weekend. That seemed like a bad idea. So we're looking at the 9th and 10th. Are there any other comments or concerns about the site visit? What I will do is, in a procedural ruling coming out of this pre-hearing conference, I will clarify further what my intent is, and then also set some deadlines about coming up with an itinerary and a list of commenters and the subject matter of their comments. I think we can also finalize any issues with the site visit on August 19th and address those when we meet on August 19th, assuming we have some time after we've heard policy statements. Anything else on the site visit? All right, I think next on my list is order of proceedings. I don't know that we need a whole lot here. It sounded like there were no objections to the general order that I had identified. The NGO groups, I think, asked generally if you can order amongst yourselves, and I have no problem with that. You know, whatever presentation makes sense for you, and also in terms of cross-examination. The only thing is, I will ask at some point in advance of your presentation of witnesses to identify the order you anticipate, and you can mix them up. I think that's fine. But I just want to make sure that the other parties know who's coming in what order, so that they can have a chance to prepare their cross-exam questions and have fair notice of that. So I think that makes sense to me. And then I appreciate that the NGO groups and others have worked together, and you've grouped yourselves, and it sounds like you have a proposal. I'm not sure how that's going to work on cross-exam, and you may not know either. It sounds like some of this is getting worked out. You also haven't seen the direct testimony. So again, acknowledging that time limits for cross-examination and how that's going to work is an issue we still have to address, but that's a little difficult to do before we see the direct testimony. But if there are any comments further, either about the order of proceeding or grouping for purposes of presentation of witnesses or cross-examination, please feel free to raise your hand and comment at this time. All right,
I was just gonna say very quickly, there was some discussion about who's being like the tribes not being represented, and we're trying to do this as a kind of a common interest. Folks that are all aligned, and some will have representation, some will be represented, but we will, in terms of council, but we will work together with all the groups to have a cohesive presentation, and some of that, and then some of the groups may be added within the representation. So,
thank you, Mr. Mooney, and I do appreciate, and you've, I think, all raised this quite well, that I appreciate your working together, and then also appreciate that there are interests that are not, that there are different focus in your interests, so you are not equivalent to one another. So I appreciate that, and I understand that. Ms. Meserve. There we go.
I just couldn't get it to come up on my phone. Thank you. Just one note on the groupings. and I think we could defer this out to later, but just, and you kind of, we referenced it a little bit, but it might be appropriate to do some subject matter groupings that go across even broader groups. You know, for instance, we have a fisheries expert for our group with San Joaquin and Central Delta et al. And it may make sense to put that fisheries person with, you know, some of the other fisheries testimony. So I guess we can figure it out later, but I just kind of want to put a place saver for having those conversations. It may make more sense to put those folks together, even if they're representing, you know, different subsets.
I can see that. That may make sense. I think I may look to all of you to talk to one another if that seems appropriate and bring me something. But I guess I
Yeah,
wouldn't
we
split
can
up
do that.
anyone's. Yeah, I don't want to split up anyone's case in chief without them wanting to do that. But if that makes sense, I think that might be quite helpful in terms of we can all focus on water quality and then we can focus on other things, you know, however it may play out. So thank you for that suggestion. Anything to enhance efficiency is much appreciated. Is there anyone else on those issues? I'm going to move to the court reporter next. I know there's there is not an agreement. Mr. King, did you want to address something we've already talked
So on
about?
the policy statement, has there been any change in the parties that are going to give policy statements? My understanding that Blue Diamond Growers is not going to appear. Do we know?
I don't have a note about that. If that came in, it may not have reached my radar because I think they're still on my list. Yes, they are still on my list.
Okay. I saw some emails to that effect. So perhaps my understanding is they weren't going to appear. So maybe I don't know how I should. I guess they have to tell you specifically they're not going to, if they're going to or not. Is that right?
Well, if they don't show up, they don't show up. But I would prefer if they let me know if they're not going to appear, and they may have. So I'm going to look to my team. Hopefully is hearing this and will let me know if that came in, and maybe we can confirm before we break for today. So thank you, Mr. Fong. The court reporter. It sounds like there's not an agreement on costs. I also appreciate Mr. Ferguson, you pursuing an estimate of how much it would cost. These things are expensive. I think the way to go about this is, I mean, we need a court reporter, right? I think we're all in agreement that that makes sense and that the transcripts will be quite helpful. And it really is inefficient to, as someone who's done this, it's very inefficient to try to get transcripts after the fact. It's much easier to have the court reporter in the room. That we have everything audio visual recorded, but transcription after the fact, in my experience, is very time consuming and doesn't work very well. So I'll look to you, Mr. Ferguson, if you have comments, but essentially my sense is if we don't have a court reporter and an understanding of how this is going to work, we can't go forward with this hearing. So if you have any suggestions as to how we work this out, otherwise I think it's a conversation that you need to continue to have. I don't believe I have the authority to order anyone to pay for the court reporter, but I don't see how we can proceed without one. So do you have any comments, Mr. Ferguson?
Well, I appreciate what you're saying, and certainly the authority wants to have a transcription. I will just offer that it wasn't stated in our pre-hearing conference letter that the authority certainly has a benefit or gains a benefit from the transcripts, but I would say the protestants do as well. To the their ability to prosecute their protest in this proceeding and in court depends in part on a transcript. So that was the basis for us suggesting the 50% authority payment and 50% protestant group payment. The authority's willing to go higher, I mean, and pay 60% if the other parties are willing to shoulder 40%. And that's, a proposal the authority is willing to make at this time. And maybe you don't want to have a back and forth at this point. We can certainly continue that conversation after this call, but I'll just throw that out there for now.
So I appreciate that. So here's what I'll say is I think, please continue to have that conversation. I think that start of the evidentiary hearing on August 27th is going to be contingent on having a plan for a court reporter in place. I think right now what I'm proposing is that we use the opening policy statement day on August 19th as a joint policy statement and pre-hearing conference. If we do not have an arrangement for a court reporter by that date, then I have to check with our budgets, but I think we can retain a court reporter, and that would be the one more time so that we can have transcripts of that discussion on that day. But maybe I guess the way to say this is, Mr. Ferguson, if you can report back to me when you have more knowledge, but with the understanding that the August 27th start date is going to be contingent on having a plan in place and having a court reporter. Mr. Busher, did you want to comment on that?
Yeah, Eric Busher, San Francisco Baykeeper. So we agree with the importance of having a court reporter. We have a fundamental problem with being as an entity that will not benefit financially in any way from the project, of having to pay the cost of that court reporter. That creates a financial prerequisite to participation in these proceedings for all of the protesters who will not benefit from this. And the proposal so far includes no funding for a court reporter from either DWR or the Bureau, which, to the extent Sites is not going to pay the whole thing, we think that would be the next place to look to make up that difference, not as a condition of protesters being able and public interest groups being able to participate.
Thank you, Mr. Busher. And I think that your points were well laid out in the pre-hearing conference, again, because I don't, unless someone tells me otherwise, I don't think I have the authority to direct payment from any party on the court reporter, but we're left with this conundrum, which is interesting. It comes up later. This is a little bit of an aside, but there is, I think, an open question about, in preparation of an administrative record, whether the party, requesting preparation of the administrative record, essentially the suing party, has to pay for transcription as part of that. I don't know the answer to that, but in any case, I'm hoping we can avoid that entire question and get this worked out in advance. So I appreciate you having frank conversations with one another. I appreciate your efforts, all of you, and I will await an update from you, Mr. Ferguson.
Okay.
Thank you. Next, I wanted to turn to the state water contractors settlement agreement. The letter with respect to the settlement agreement, it came in fairly recently, but I did read it carefully, and I really appreciate the efforts going into coming up with proposed permit terms. That's very important. I think it'd be very important to Ms. Meserve, did you want to chime in on the court reporter on the next question?
Sorry, I'm not operating my phone very well. I just wanted to point out that, with respect to your comment about future proceedings, there's one of the things about the streamlining under CEQA, at least, is that, the agency is required to prepare the record in these kind of leadership cases. So there's already going to be a requirement on Sites probably to have that done. So I guess it's just kind of a fundamental fairness issue, I think, from my standpoint, and I would think most of the protestants, when this project, I was trying to look it up quickly, but literally hundreds, I don't know if more than 100 million in public funding has gone toward this, but all of the protestants are having to fund it through their agencies or entities, and all the work to have the experts and the attorneys and everything else that goes into it. So it's kind of a David and Goliath type thing. And I think that's part of why we're so not agreeable to a share.
Thank you, Ms. Meserve. And understood. On the state water contractors settlement agreement on the letter, I've read it. There are proposed permit terms. The terms themselves aren't actually that complicated, but I think the concepts are complicated. So it's a tricky question of how do we deal with this, where we have a proposed permit term that would settle a protest, which is great. I think there's some potential, I hope, to streamline our proceeding based on that resolution. On the other hand, I think other parties will have concerns and interest in how any such permit term would actually work. And then there's the other tricky position where even if I wanted to, I can't commit the board, right? So even if I think you have the most wonderful permit term there is and any approval should include it, I don't get to make that decision. And the board gets to make that decision, and the board can't make such a decision unless they have a open and public meeting and go through the appropriate process. So it's not clear to me how the board could commit to permit terms when there's a hearing process in advance of actually conducting the evidentiary hearing. On the other hand, I'd like to gain any efficiencies we can from the fact that there is an agreement in place. So I don't have the answer right now. But maybe I can look to state water contractors. Do you have, given on what I just said, do you have I understand you want to protect your interests. You want to make sure you're represented. I guess I should add, it made sense to me that what you indicated about dismissing the protest or conditionally resolving the protest, however you want to phrase it, but continuing to participate in the proceeding. I understand that as well. But I'm not sure how to eliminate the need for you to put on a case in chief, given that we can't make a commitment that the permit terms would be incorporated in any permit in advance of conducting the hearing.
Yeah, I understand that concern. I think what we're asking for at this time is for the site's application to be amended to include these as the proposed permit terms. Does that raise the same concerns for you?
No, I think that's the prerogative of the authority. And then the question would be, does that amendment raise any noticing issues? I don't know. We could go back and forth on that. But I think that would be right within the prerogative of the authority to amend their own application. Is that, Mr. Ferguson, does that reflect your, I'm not asking for commitments, I just want to talk through some of these issues. Does that reflect your understanding of the agreement?
Yes, it does.
Okay.
And that was the letter was structured in that way to be from the authority, the contractors, and DWR. And so to the extent the authority signed on to that letter, it was with the anticipation that it would become part of the application package.
So that it actually is, the letter itself is an amendment to your application.
I guess so. Yeah, effectively.
Yeah, effectively. Okay. That is a very helpful clarification. If I have additional questions once I contemplate how that works, I know you have this deadline coming up, right? So this will affect, maybe you can speak to this, Ms. Johnson. You are trying to figure out whether or not you should submit case in chief evidence and go through the effort of, I assume, of compiling that testimony. So you'd be looking for some clarification on what can I offer that would provide some clarification?
Right. We're looking for clarification that one, the application is in fact amended to include these two permit terms, and two, that if our protest is dismissed, we will be granted interested party status.
Yep.
That will allow us to cross-examine and rebut as necessary. Look, we're looking to take as narrow of a role in this proceeding as required. But we do think we may need the opportunity. So with the clarification of those two issues, we would ask to have our protest dismissed.
That's very helpful. Thank you. I think I understand that. And with that clarification, are there any comments from any other parties on what is being asked? Mr. Mooney, please.
Yeah, you raised the potential issue of the kind of a procedural and notice issue about amending an application at this point in time. And well, I've looked at those proposed permit terms. I'm not sure now if we have to, what experts we have to inform them of that, of the amended application, and how that will affect the preparation of their testimony. And the, we have a July 1 deadline. So is it being formally amended today, or is there a notice procedure? I mean, Mr. Ferguson just indicated, yes, it's an amended application, but does the submittal itself actually constitute an amended application. And I guess I'd have to go back and look at the state board's regs in terms of what are the notice and procedural requirements. Have they followed those? And then the second one is, how does that affect our preparation of testimony at this point in time? I mean, I don't, I think it's good that they're working with parties and trying to resolve protests, but the idea was to resolve protests a long time ago. And then that gives all the parties notice as to how that resolution of that protest would affect the hearing going forward and the testimony. And so we have not had time to necessarily digest all of that with what apparently is an amended protest, or amended application and resolution of the protest at the last minute that may or may not affect the testimony that we're providing, we're having people prepare.
And I thank you, Mr. Mooney. I also have to go back and look at the regs, so that point is well taken. Just to make sure we are following the rules. I think the way to deal with this is to acknowledge that this to some extent is new information, right? The resolution of the protest is new information, and it's proximate to the deadline for cases in chief. So as things come up related to the amendment to the application, that may, I don't want to make a commitment, but that may be a basis to allow whether it's revised testimony or updates to testimony submitted as part of the case in chief. We have some time, so that it may be that there needs to be an opportunity to look at that. So if that comes up, bring it to me. If if your experts are looking at this and then later after they submit their case in chief testimony and think, oh, we weren't aware of this because of the amendment, that might be a basis to allow for some revisions to the testimony. Just trying to think of the most efficient, how to move forward on this in a way that's fair.
Yeah, I understand that, but there is an issue of fairness in that we do represent groups. The groups here are primarily groups of limited financial means, and then asking experts to go and revise their testimony at a later date or add to their testimony at a later date when all of this could have been done earlier. Only kind of almost to that transcript issue. It only kind of adds to the financial burden of the protesters of having to continue to pay experts more when this all could have been done earlier, and or we could all include it all in once we get the formal application or formal amendment and the procedures required, we'd be able to present something to our experts and say, here's what the project is now.
Yeah, that's, I guess, and that would be my next question for you is what would you propose, right? Because I think it makes sense to a streamline, right? If the authority's application is now more specific, that's helpful to everyone. We obviously want to make sure that the rules and regulations for amendment of an application have been followed. So that's something to look to, and that I don't want to do that on the fly. But what is it that you're asking for?
I mean, we just found out 5 minutes ago that this constitutes an amendment. So I'm not exactly sure what we're asking for. I think we're asking for consideration that it's be checked that the rules and procedures are being followed, and that it doesn't put increased burden on our, my clients and the other folks, other protesters to this in terms of responding, because we're doing it, as Mr. Ferguson said, everybody's had notice of this for a long time, and the state board has a date for reporting back on the status of protests. And that's not to say people should stop working to resolve their issues, but there's a date for that reason, and that date was set before the hearing notice went out.
But I think Mr. Mooney, though, I have to say, but it doesn't make sense to say, does it? To say, well, you can't amend your application. I mean, are you suggesting they shouldn't be allowed to amend their application?
No, I'm not. But what I'm suggesting is some consideration should be given to the timing of things, and the hearing officers, your consideration for, first of all, for the July 15th deadline, but your proposal about that there would be, and since I like the proposal that there might be some leave for experts to amend their testimony, and I think that's one possible solution if this affected that. But the downside of that is, again, we represent folks with limited financial means, and then to go tell folks you have to, now that you've prepared a report, now some of this has changed, and again, I don't know how much that's going to affect, if it's going to affect one expert's testimony, or if it's going to affect 10, or if it's going to affect 0. We just don't know that now. But to say, well, just go ahead and do that and continue to bear that financial burden because of the modifications to the project as we're going to a hearing, that just puts a bigger burden on the protesters. So
Understood. Thank you, Mr. Mooney. And I want to, and I'll maybe elaborate. Well, let me hear from the other parties, and then let me return to you. I think probably Mr. Ferguson, go ahead.
Yeah, I just want to be careful to clarify that I said it effectively amends the application to the extent by saying it amends the application or effectively amends the application, we're triggering some sort of a new noticing process. I would I'll take that statement back, because I don't even know that it's necessary to have it constituted as an amended application, because throughout the hearing process, for example, the hearing officer could propose new terms and conditions that were never contemplated prior to the hearing or at any other time. So new terms and conditions could come about throughout this proceeding and be put right into the permit at the end without any formal amendment of the application. And so I just wanted to be clear that I didn't, to the extent that that would trigger some sort of new noticing process, we're not committing to that at this point. But the authority is certainly committed to having this put in the permit once the hearing officer issues an order and once the board approves an order. And I guess I would also just say that the hearing notice contemplates continued settlement discussions throughout the hearing within the hearing procedures at the back of the notice. So it's certainly reasonable to have continued these discussions beyond the prescribed noticing period. And the authority believes it's creating efficiencies by reaching these settlement resolutions. And parties are certainly available to, or certainly able to cross-examine our witnesses on these proposed terms. And if they believe it's necessary to offer evidence on these terms, they can do that in rebuttal. So there will certainly be opportunities to test the details and of these terms, even at this point in the hearing.
Thank you, Mr. Ferguson. I'm going to turn to Ms. Johnson because I think she can help, because I thought Ms. Johnson told me that she wants to make sure that the part of your agreement is that the application is amended. And now it sounds like, no, it's not going to be amended. You have an agreement between the party, because I think you can come to an agreement right between your two entities about what's going to happen. I'm mostly right now trying to pin down what it is I need to do to help support this process that's within my authority to do it. Because there certainly are efficiencies to having permit terms worked out. And I do certainly appreciate, I'm sure there was a lot of time and effort that went into getting to where we are today on those, and that helps the State Water Board come to a decision. So I want to support the process itself while, maintaining this. So maybe I'll hear from Ms. Johnson, and then we'll go back to you, Mr. Ferguson, and Mr. Mooney. I've not forgotten about you either. So.
Right. And I appreciate what you're balancing. And I just want to point out, I think, we're not the only protest to settle taking a similar approach. The language we did use was that the application would be amended to include these permit terms, but there's already been a similar settlement, and I imagine there are others here on this Zoom who are maybe seeking terms or changes. And so to think that every time this is going to trigger some sort of renoticing, seems perhaps an unproductive way to proceed. The most important thing for us is that we've reached agreement with DWR and sites. And, you know, I understand these have been before the Bureau as well. However we can help resolve this, we are looking to streamline, not disrupt proceedings.
Thank you. Mr. Ferguson, did you want to jump in again?
Yeah, I don't know if there's much more for me to say. The authority is certainly committed to, like I said, having these terms in its permit. If that takes something called a formal amendment, then the authority will proceed in the way it needs to proceed to make that happen. I just wanted to be careful that committing to that now didn't raise some sort of a noticing issue that the authority may be unaware of or not be expecting. So, because again, I'm not convinced that noticing is required.
So,
but
I'm still trying to figure out what it is I should do. I certainly within my authority to memorialize this understanding that state water contractors can continue to participate, regardless of any agreement in terms of permit terms, that state water contractors can continue to participate as a party in this proceeding and put on evidence and cross-examine or as you see appropriate. That makes sense to me. What else?
I think you can assume that the permit term, that the authority is supportive of the permit term being part of its application. And if that is done, if that needs to be termed an amendment, then that's
well, let me put it
fine,
this
I guess. I just want to I want to understand if there's a noticing issue. Because we may want to have some further discussion about it to the extent you're prepared to say that there's a noticing requirement of some kind.
So there's a question of, is there a notice requirement? What I see, and this is, this is not a decision, so we're talking this through and this is quite helpful. I think the difference to me is if the permit term is part of your application, then when the board considers the application, if the board were to approve it, that approval would necessarily include the permit term because it is part of your application. If it's not part of your application, then the board can decide whether or not to include the permit term, right? Because your application doesn't have it in there. That is my sitting right here, not pre-deciding anything, is my understanding of the difference of what an amendment, formal amendment to your application would mean, right? Whether or not the board can approve it with different term. Otherwise, it's the board just, if the board doesn't agree with the permit term, then they just deny the application because that's not what you asked for.
But I guess that was my point in mentioning that you as the hearing officer through the hearing could possibly impose new terms and conditions that were never in the application.
Correct.
And in that situation, there wouldn't be an amendment to the application in order for those terms to be part of the permit that the board is considering.
Yes, no, I think the board can't, one possibility is that the board would approve this application with the term exactly as you proposed it, right? It's just that without an amendment, another option is the board approves the application without the term as you propose. That those are, and then the third possibility is denial. Right, that those are all paths.
Yeah,
I'm trying to be clear about it so that Ms. Johnson knows on behalf of her client what.
Yes, I was just going to suggest that that's the authority is attempting to be a cooperating partner here, but the risks it sounds to me for those last two scenarios are to some extent on the contractors.
Unless I can give some clarification about noticing requirements, in which case it sounds like the authority may be willing to amend their application. Are we getting down to the meat of it?
I think it would be very helpful to get some clarity on the noticing requirement and also whether there's any difference for, this request being made during the protest resolution process versus after. This is not an issue that came up in our discussions, and so it's a lot to process here in the moment, but certainly without even knowing what the notice requirement is, it's hard to say that, there's a need to change approach or not.
So I think here's what I'm thinking we might do. I think we all need to go back and look at our statutes and regulations and think about what this is. All of us in the room. And then I think what may make sense is to get briefing on this issue. Unless we all are in agreement, in which case we don't want to waste our time. So maybe what I'll say is I can give an initial, would it be helpful? Let me ask it this way. Would it be helpful to the parties to get my sense after reviewing the applicable law about what would be procedurally required to amend the application, and then allow everyone an opportunity to respond to that interpretation? And then Mr. Ferguson and Ms. Johnson, you can make a decision about how we should go forward, understanding, Ms. Johnson, that the deadline for case in chief submittals is rapidly approaching, but I'm not sure what to do about that, but we may have to work it out. Mr. Ferguson, did you have a thought on this approach?
That approach sounds good to me.
Okay. Ms. Johnson?
Do you have a sense of the time it would take to get that sort of advisory first take on the applicable law?
No.
Okay, fair enough. Fair enough.
That would be, I mean, obviously be helpful to know before the deadline for case in chief submittals. I guess what would be the most helpful to you?
Well, we'll be doing our own research as well, but the sooner we have clarity, the sooner, we can consider how to proceed.
Yeah, yeah.
We can certainly develop some contingency plans.
Yeah, I will try to do it as quickly as possible, but as these things are, sometimes you open, I hesitate because I open a box that it's unclear. It may be that the answer is it's not clear. Mr. Ferguson, back to you. You're all okay. Residual hand raise. And I want to look to the room, other parties. Mr. Mooney, I assume obviously you would want a chance to chime in on this, which I would fully support and accept.
Yes.
Yeah.
I like that approach, and reason for one, because of the time constraints. If the state board looks at it and says, this is how we want to proceed, and the parties agree that that's what the regulations or the law says, there's really no need for us to even respond, and the decision's made, as opposed to if you give us a week or something to do it, and then the state board comes back, and it just seems like something that would delay the process, a determination. So I like the hearing your approach.
Okay, thank you, Mr. Mooney. And Mr. Reese.
No, I'm fine with that approach. We'll respond as needed.
Okay.
You don't need additional briefing at this point in time if we don't have to do it.
Right, you have some other things to work on, all of you. Okay. Thank you for that discussion. That was the issue. I knew it was hard, so I appreciate the back and forth on that. And I think we're all trying to do what's efficient and fair here. Mr. Ferguson, the last thing on my list of things to talk about, and before I turn it over to the room, is the water availability question. I think the authority had raised a question about the role of the division and division staff. I assume this is prompted, and I wanted to provide some explanation, prompted because the amended hearing notice broke out the section discussing water availability, the analyses that the authority submitted, and attached that as an exhibit. And I did make the decision to do that to try to make clear that to the extent that information has been partially digested, in the sense that it's not straight out of what the authority had submitted or anywhere else, and may include disputed questions of fact and difficult technical analyses, that wasn't a determination by me in any way, or a determination of the facts. So we broke it out separately. It was an attempt to be informational for the public who's reading these notices about the division's understanding of what those different approaches generally are, but was not intended to be a reflection of any determination by the hearing officer or by the board, certainly. In terms of division staff preparing an additional report, that's not the intent. It's not that, and I'll give you a chance to clarify maybe what you were asking, but it's not my understanding that division staff will be preparing any any written report on which the hearing officer or the board would be relying in terms of water availability. We'd be looking to the evidence that the authority is planning to submit, and then any evidence from the other parties with respect to water availability. So with that clarification, are there other questions is there further clarification that I can offer on that issue?
There isn't for the authority. That explanation is helpful.
Okay.
Thanks.
Thank you. Mr. King.
Yeah, so when the Inclusive Groundwater Authority filed its groundwater sustainability plan in conjunction with Land Groundwater Authority, they filed a plan that alleged that the subbasin was sustainable. And then the board, the DWR deemed that submission be incomplete, and it's clear that it's not sustainable. And that letter from DWR came in October 23. I believe that it's necessary for flows from both the Sacramento River and from the streams into the Coosa Trough. Those flows are needed. Part of those flows are needed for groundwater recharge projects to make the subbasin sustainable. And so I don't know do you want to address that, but there is additional information that after the application is filed, that there is need for both Sacramento River flows and from flows from the streams that flow in Coosa Trough for groundwater recharge to make the Coosa Basin sustainable. And so the water availability study, I imagine, was done before the DWR submitted their letter in October 23 regarding what's needed for sustainability. And I would think that there should be some reconciliation or some coordination between what the DWR has deemed necessary for sustainability and what was included as what supplies were available in the site's authority's application.
Thank you, Mr. King. It sounds like what you're saying to me is that you might consider submitting, whether it's the GSP, the groundwater sustainability plan, or probably DWR's letter assessing that GSP. The hearing, I will look at it and the board will look at it if you submit it as an exhibit and it's accepted into evidence. So that's the pathway.
Thank you for that. Yeah, thank you for that. I will. Thank you.
Thank you. This is the time, I think, where I open up and ask, now that we've all enjoyed a long morning together, are there other procedural issues that we should address at this time? I understand there are a number of to-do items. I've had, I'm at the risk of forgetting something. I'm not going to tick them all off. I've had my team, asked members of my team to help me keep track of all the things that are on my plate, and then also for you. I do intend to get back to you tomorrow or Wednesday on the deadline for case in chief exhibits. That's very important. And related to that, clarity on when the PowerPoint presentations for witnesses presenting summaries of their direct testimony and when that would be, so that there is clarity for all of you on that impending deadline. But are there other procedural issues we should address today? My intent would be we'd see each other again, absent a request from one of you that we have to get together sooner, on August 19th. That would be both the opportunity to present policy statements. Oh, Mr. King, I'll finish this thought and then I'll get back to you. You had that one question about the Blue Diamond growers. We would see each other on August 19th. We'd hear policy statements from interested persons. That will be conducted as a hybrid meeting, so there would be an opportunity to attend in person or on Zoom. So you may continue to participate on Zoom if you would like. We'll submit more information about procedures because of how that hybrid process will go. It'll be conducted something like the State Water Board regular meetings that are all hybrid. So we'll do something like that. There'll probably be speaker cards that you can so we can figure out an order of proceeding, but we will provide more information about that. But there is the opportunity to appear in person. There may be a quorum of the board present. We will notice that if that is going to occur appropriately. But there may be a quorum physically present for that opening. I'm just not sure yet at this point. On your comment question, Mr. King, it sounds like my team says that we see that the Blue Diamond growers filed an NOI, but we don't see. Right now, we didn't conduct a complete search, but it doesn't look like we received anything about them withdrawing that NOI or intending not to present a policy statement, but we didn't have a chance for a complete search. So that might be, if your understanding is different, that might be a follow-up question. Mr. Schutz, please go ahead.
Yes, I have an administrative question. At times, I seem to have difficulty either logging into the FTP site or communicating through the AHO-sites reservoir, or whatever it is, the various email addresses. And it seems to be related largely to the fact that it's not a specific person. Would it be possible in the event that I'm having that kind of technical difficulty for you to designate one of your staff as the person that I can email in order to resolve these issues? Because the sort of generic emails themselves seem to be problematic, and trying to email an address that you can't email doesn't solve the problem.
That's certainly true. That's what I'm concerned. What is so the email itself doesn't go through? What is
Correct. It gets sent back.
That's interesting. Okay. I will talk with my team and we'll find out who but yes, it is frustrating to not have a person. And I would like to avoid that kind of bureaucratic no name.
Administrative, yes.
Yeah, so yes, I just want to make sure I'm going to talk with my team and make sure we pick the right person, and that's all. But we can send that out. I would send it to the entire service list so you have a backup email for these, and so that if there is problems reaching the larger email address. The nice thing about the reason we have this larger group, the site's reservoir email list, is because we have a number of staff who sometimes go through the inbox, and so it's nice to have that so that all the staff we process faster, but it is also sometimes good to have a particular person. So thank you for that. Thank you, Mr. Schutz. Mr. Ferguson.
Yeah, thank you. I just wanted to say that there are a number of substantive comments made today, and since we certainly understand this is a procedural proceeding, we kind of restrained ourselves in trying to respond to each of those substantive comments, but there's certainly a number of those comments we continue to disagree with. So I just wanted to make that clear for the record.
Understood. Thank you, Mr. Ferguson. I thank you for your understanding here. There's no evidentiary, as you know, they're not evidentiary value. They're not under oath. I think it's a matter of, as you've seen, I was trying to get down to the procedural issue that was behind these somewhat substantive comments, and I appreciate all of everyone's professionalism and as appropriate restraint as we work through this. Is there anything else for today? All right, with that, I do want to thank all of you for your participation today. You will be hearing more from my office as we really get this going. You will hear from me within the next day or two on those deadlines. And thank you for spending your morning here. I think this was extremely productive and helpful. And I hope all of you have a wonderful rest of your week. We are adjourned. Thank you.
Thank you very much.